appeal in the matter of McLaren and MOL.
Yes, Mr. Mitri. We've read the skeleton arguments and the tribunal's decision, and we've certainly looked at the authorities, but I don't think it stop you from taking us to any particular part that you want to look at.
My Lord, thank you very much. Would you like me to do introductions?
By all means.
I, with Mr. Pitchinen, represent the MNW Appellants. That's all of the defendants except for Defendant 5 and Defendant 12. Mr. Singler with Miss Blackwood represents the KK Appellants. That's Defendant 5. And then we have the class representative, Miss Ford, with Miss Mockford and Miss O'Keefe.
Yes.
Just a question before we start about timetable. So on our side, we took the view that it would make more sense to deal with the appeal first, and then, so in other words, deal with all the matters relating to the main appeal, and then deal with the cross appeal separately, because that raises very different issues. Miss Ford takes the view that it would be better to wrap them up together. And so, in other words, we open on the main appeal, she responds on the appeal and opens on the cross appeal. But really we're in your hands as to what you would find easiest.
I would find it easiest whatever suits you best. And I really don't want to adjudicate on timetabling.
No.
There are other more important things to adjudicate upon.
Why don't we get Mr. Singler to toss a coin?
I have no coins, my lord, but we do feel that it would make more sense and be of more assistance to the court. And by way of background, this appeal was listed for 1.5 days. The cross appeal subsequently was allowed, and an extra half day was permitted. So we do respectfully submit that in order for your lordships to follow the arguments more closely, it would make much more sense for us to go in the conventional order, main appeal. Cross appeal, of course, only arises if we're wrong about the main appeal. So for those reasons, we do submit the natural flow is main appeal and a half day tomorrow for the cross appeal.
Any violent objections to that, Miss Ford?
My Lord, we're in the court's hands.
All right, well, we'll do that.
So that means you're dealing with methodology in its totality. And then, so far as the Fulton point is concerned, is that wrapped up in...
I'm dealing with that, so that's wrapped up. So we have one ground of appeal, the MNW Appellants, which is that there's a methodological flaw, and the Fulton point is relevant to that. So I'm dealing with that. Then
we deal with deceased persons separately.
Yes, exactly. So then Mr. Singler will follow me because KK have a different methodological point. Then Ms. Ford responds on methodology, and we reply on methodology, and then you have separately tomorrow the entirely discrete deceased persons issue.
We resurrect the new appeal.
My Lord, so may I start then with our point? So the claim, as you've seen, arises out of the Commission's decision establishing that the defendants participated in a cartel concerning the provision of deep-sea shipping services for new motor vehicles. Damages claims have already been brought in the English courts by car manufacturers who allege that they paid an overcharge for the delivery service for the deep-sea shipping services when they shipped vehicles into the EEA from countries outside the EEA. And these collective proceedings are different. They're claims brought by the purchasers of the motor vehicles themselves. So the class representative alleges that the class members, customers who bought cars, suffered loss as a consequence of the cartel. And the basis for that allegation is that they say that the manufacturers, the car manufacturers and retailers, passed on the cartel overcharge relating to deep-sea shipping to the class members when they purchased their cars. So that's the basis for the claim. But we say that at the outset that it's important not to let the competition law jargon of pass on obscure what the class representative really needs to prove, which is that the class members suffered loss on something that they purchased. That's really the key point. And the case that the class representative has pleaded alleges, this is their allegation, that members of the class have suffered loss as a result of paying, and I'm quoting, unlawfully inflated delivery charges. And that's the pleaded measure of loss. And the methodology that's been advanced is designed to estimate that loss by measuring the impact of the cartel on the delivery charge made to customers. And really our short point in a nutshell is that both the pleading of the class representative and the methodology are aiming at the wrong target, the wrong measure of loss, because class members have not purchased a delivery service, they've purchased a car. And in order to establish that the cartel caused them loss, and if so, how much loss the cartel has caused them, the class representative needs to establish that the class members have paid more for their cars than they would have paid absent the cartel. But we say that's not the class representative's pleaded case, and it's not what its methodology is designed to establish. And for that reason, we say that the claim should be struck out, and we also say that the methodology is relied on is inadequate and fails the Microsoft test, which this court recently considered in the Gutman case.
Assuming that they are aiming at the right target, you say it still fails the Microsoft test.
Well, no, the 2 points are bound up together. So we say that they're aiming at the wrong target, their pleading aims at the wrong target, pleads the wrong case, and their methodology is designed to estimate the loss that they've pleaded, which is the loss on the delivery charge.
Right, so it's the same point.
It's the same point, but it fails for 2 reasons.
Yeah.
So I proposed to make my submissions as follows. I was going to take the court to the pleadings and to the methodology briefly. Then I was going to develop our submissions on why we say that the pleading and the methodology is wrong, because they target the wrong thing. Then I was going to take the court to the judgment below, and then finally I was going to address the response of the class representative. So if that order seems logical to the court, yes. I'll start with the claim form, which is in the supplementary bundle behind tab 1. And if we can take it, please, from page 3. You'll see at paragraph 7 how the case is put. So that it's combining the claims of consumers and businesses who purchase new cars and light medium weight commercial vehicles during the relevant period and were required to pay, and I'm emphasising the next words, an unlawfully inflated delivery charge in respect of those vehicles because of the proposed defendant's unlawful and anti-competitive conduct. And then, just while we're on this page, if you could cast your eye down paragraph 8, because that factually shows you the supply chain, which is not in dispute, it's just useful to have it in mind for what follows. So you have the OEMs, the original equipment manufacturers, which design and manufacture the vehicles. And so they're responsible for shipping, and they pay the costs of shipping. And then if you go over the page, what they do is they then supply the cars to national sales companies. You see that from subparagraph 2, so NSCs, which are typically their subsidiaries. And those then distribute the cars within a particular the country where they're going to be sold to individual dealerships. And then you see that you can see from subparagraph 3 that the NSCs recommend delivery charges to be paid by the ultimate consumer, ultimate customer. And these are set by reference to the costs of the OEMs and the NSCs, including the deep sea shipping costs, which you might have seen referred to as RORO, roll-on, roll-off costs. And then subparagraph 4, it said that, of course, then what happens is the dealers sell the cars to the customers, to consumers. And at subparagraph 4, it said that in the majority of cases, the delivery cost is itemised on the invoice presented to the customer. But it's common ground that some significant brands did not operate in that way, so didn't itemise the delivery charge on invoices. And we see that in the respondent's own evidence. There's no need to turn it up because it's common ground.
Does it matter whether it's separately itemised?
No,
I mean,
we
suppose
say,
the cartel were in tyres or windscreen wipers.
We say it doesn't matter. It doesn't matter. In a sense, it fortifies our point, because in order to make good their claim, for manufacturers for brands that don't itemise it, what they're having to do is reconstruct some kind of notional delivery line item in the invoice. So we say it highlights why their claim is wrong-headed, but it doesn't matter as a matter of substance.
If it were windscreen wipers and there was no separate identification on the invoice, they would still be an element of the final global price, which was inflated artificially.
My Lord, yes. So it's a very good analogy, if I may respect.
Isn't that the same for delivery? There is an element or a component of the final price which is inflated.
My Lord, yes. But then the question, so let's say take windscreen wipers, or in fact take seatbelts, because you'll probably be aware there's been a cartel of seatbelt suppliers. So take seatbelts or windscreen wipers, which are a component of vehicles. And let's say that as a result of a cartel, the price for supplying windscreen wipers or seatbelts has been inflated. And so the car manufacturer pays over the odds for the windscreen wiper or the seatbelt. And they seek to recover that cost from the consumer, from the purchaser of the vehicle. Whether or not the purchaser of the vehicle has suffered loss will depend on whether they've paid more for their car, because they're not buying a separate seatbelt or a separate windscreen wiper. So it may well be that the manufacturer seeks to recover their input costs when selling the car. But the question is, has this consumer, in order to have a claim, the consumer needs to have suffered loss. And so if they haven't paid more for the car, there will be no claim. And that really is the fundamental point in this case. So we say the present case, which is the delivery charge, is no different to seatbelts or windscreen wipers. And if you had a class action of consumers based on the seatbelt cartel, they wouldn't be able to come along to the court and say, oh, well, the seatbelts have been inflated artificially. It doesn't matter what we paid for the car. We may have paid exactly the same amount for our car, but we're entitled to recovery. That just wouldn't be a claim.
But you're making the assumption that somehow the overcharge has been smothered away, disappeared, evaporated, instead of passed on.
Well, what we're saying is that it's not right, as a matter of law or economics or common sense, to silo each individual cost component that goes into the ultimate price. Because as we've said in our skeleton argument, money is fungible. You can't say, well, this cost stays rigidly as so and comes out in the final wash as X, because the question in any case, that's why I say pass on, in a sense, is obscuring the issue that the court has to determine. Because the issue that the court has to determine is, has there been loss on the part of these end consumers? And they have only suffered loss if they've paid more for their cars. So what one doesn't do in a competition...
So what do you mean by only paid more for the cars? If the tribunal finds at the end of the day that it is the intention of either the cartel and or the manufacturers to pass on that delivery charge in one way or another, then in some form, even in a tiny fraction of the total price, there will be an ingredient or a component which is overcharged.
My Lord, no, we don't agree with that. Can I take it? Because
is that a question of law or fact?
So we say that that's a question really of law, of what is the loss that can I take it in stages, if I may? So
yeah.
Because I am going, when I elaborate our submission, I am going to grapple exactly with that point. But it may be easier if I just take it in stages rather than fast forward to the punchline, as it were. Because if that's all right, I'm not going to take very long.
You build up to your punchline.
Can I build up to my punchline? Thank you. Back to the pleading. So we see at paragraph 9 on page 5 that, again, what's said is it's referring to recovering that portion of the delivery charge paid by them, which was unlawfully inflated by the anti-competitive conduct. So that's the way it's put. And then if you go forward to page 14, paragraph 42 contains the proposed class, the class definition. So all persons, other than excluded persons, who during the relevant period either purchased or financed a new vehicle or new lease vehicle, other than a vehicle produced by an excluded brand. And then you see the excluded brands on the next page, in the middle of page 15, and they're listed, and they include some major brands, such as Fiat, for example, and Volvo, and so on. You see them listed there. And the reason why these brands are excluded is because all models produced by those brands were manufactured in the EEA, and so they didn't incur deep-sea shipping charges. And we see that, just so that you have the reference, on page 17. That explanation is at the bottom of the page,
yeah,
under excluded brands. And then if you look at page 18, you see near the top of the page, a few lines down, Mr. Robinson, so it talks about the excluded brands. Mr. Robinson explains in his report that taking into account the exclusion of these brands, the proposed class is likely to encompass approximately 81.4% of all vehicle purchases made in the United Kingdom in the relevant period. Now, it's not the case, I don't know if the court has picked this up, but it's common ground, the point I'm about to make. It's not the case that 81% of vehicles sold in the United Kingdom were shipped from outside the EEA and were therefore subject to the cartel overcharge. That's not the case. And let me show you briefly where this is addressed. So we'll need to just pick up the supplementary bundle. Oh, we're in the supplementary bundle, sorry. Turn to page 7 of the supplement, tab 7 of the supplementary bundle.
Yeah.
Page 323. This is Mr. Robinson's expert report, the expert economist, that was relied on by the class representative. So bottom of 323. 38 brands, do you see this 7.18b? 38 brands were included in my damages calculation. At least some of their vehicles were manufactured outside the EEA during the relevant period. In total, 13% of all vehicles registered in the UK were manufactured out of the EEA, but this had an impact on the delivery charge of 81.4%, as the NSCs which ship at least some of their vehicles spread shipping costs across all vehicles sold as part of a homogeneous delivery charge. And so what that's saying is that only 13% of the cars incurred were shipped from outside the EEA, and so were affected by the cartel in the first instance. But brands which included those models but also sold manufactured cars in the EEA spread that cost amongst all of their cars.
This is the NSCs who spread the cost, is it?
I think it's the NSCs. You're right, my lord. Yes. And so what that means in practice is that where you have a brand for which the majority of vehicles were manufactured in the EEA and so weren't affected by the cartel, the overcharge will be tiny, because most of their vehicles only a small minority of their vehicles incur the overcharge, and they spread it over many more vehicles that are produced in the EEA. So the overcharge can be measured in pennies for some brands, whereas for brands which manufactured exclusively, say, in Asia or in the United States, or mainly in Asia or the United States, the alleged overcharge is higher and in the region of £30 to £40, according to the class representative's evidence. So if we can just briefly go back to the claim form, so behind tab 1, page 46 this time, of the bundle, and paragraph 82 at the top of the page, you see that the allegation that class members have suffered loss is based on the reasons given in the BDO report. That's paragraph 82. And then paragraph 83 says that the methodology for calculating the loss, the aggregate award to the class, is set out in the BDO report. Now, how the methodology works isn't in dispute, and I think we can take this quite quickly from the judgment itself. So if you wouldn't mind turning this time to the judgment in the core bundle behind tab 11. And page 162 of the bundle. And you'll see a heading there, the applicant's proposed methodology. And at paragraph 77, the first stage of the methodology is to estimate the overcharge resulting from the infringement. And what's proposed is a before and after analysis of deep sea shipping prices, leading to an aggregate overcharge per brand. And then we see that the next stage of the analysis, so that tells you how much the overcharge is, but it doesn't say anything about how consumers were affected. And then the next stage of the analysis is summarised at paragraph 79, and that says it aims to determine how much of the overcharge was passed on to class members. And you'll have picked up from the judgment and from the submissions that the class representative served expert industry evidence from Messrs Goss and Whitehorn and expert economic evidence from Mr Robinson, which proceeds on the basis that the industry evidence is correct. And that evidence, the industry evidence, is summarised by the tribunal at paragraphs 80 to 83.
Yes.
And essentially what the tribunal says is that the OEMs pass on the shipping charges to the NSCs, that's paragraph 80. The NSCs then set a recommended delivery charge payable by the consumer to the retailer, and this might be identified as a separate line item on the invoice, or it might be part of the price of the vehicle as a whole. That's paragraph 81 of the judgment. And then what's said at 81 is that the whole of the shipping costs are said by the class representative to be passed on to the consumer in this way. And what's meant by that, sorry, if you just bear with me for a second. Yeah, so we see that it's the applicant's position, this is just above halfway down the paragraph, that the full cost of transporting the vehicle, including the shipping costs, is passed to the end consumer as part of the delivery charge. And what's meant is explained in the next sentence. This is achieved by setting delivery charges at a level that covers the OEM's logistics charge to the NSCs, including the margin, the NSC's costs at the point of import and of onward distribution, and the NSC's margin and the cost of delivery, and what the NSC considers to be a reasonable margin for retailers on the delivery element. And so that's what's meant, according to the class representative, by pass on. And then we see from paragraph 83 that increases in shipping costs are generally reflected in an increase in the delivery charge, but this won't occur if any cost increases are offset by decreases in other costs, because a minimum margin, what they seek to do is maintain a minimum margin. That's paragraph 83. And then what happens, going on to paragraphs 84 to 86 of the judgment, is that the tribunal summarises this part of Mr Robinson's methodology. And again, it doesn't terribly matter, the detail doesn't terribly matter to my argument, but in short, he says that pass on for any given brand to consumers in any given year is the lower of two figures. The first figure being the overcharge per vehicle for that brand in that year, in other words, 100% pass on, or the cumulative increase in delivery charges for that brand from the beginning of the claim period to the year of purchase. So it's the lower of those amounts that represents the figure they say is passed on. But the important point for our purposes is that the methodology is exclusively concerned with the impact of the cartel on the delivery charge line item in the invoice, the delivery charge recommended by the NSC. And what Mr Robinson doesn't propose to do is collect any data at all on the actual prices paid by class members for vehicles, let alone to conduct any sort of analysis of those prices. So that's really where we say it goes wrong. It stops short of being able to estimate loss. Now, moving to my client's response, this is...
Was that the position he was taking at that stage, pending disclosure?
No, that's their position. I'm going to show you that what they say in their reply pleading now. So their position is, that's all we need to do. Let me show you first, before we get to the reply pleading, what we said. If we can go back to the supplemental bundle behind...
At some point, can you just help us with what disclosure there might be available? Because, of course, we're not talking about the vehicle manufacturers as defendants giving disclosure. We're talking about the cartel, which is way upstream. So it'd be interesting to know what data is likely to be available.
My lord, yes, and that's... let me just try and answer that briefly now, but we can come back to it.
When you're in time.
But of course, what we're complaining about here is not the first step of the overcharge analysis, which is estimating the overcharge with the before and after analysis, where typically that kind of data is in the hands of the defendants, the cartellists, and we of course recognise that at the certification stage that data will be disclosed later, and so they're not going to have, the class representative is not going to have access to it. But we don't complain about that part of the analysis. what we say is that when it comes to measuring the loss suffered by consumers, what they need to do is look at what prices the consumers paid for cars to see whether they were higher than they would have been absent the cartel. But they're not proposing anywhere to seek any data in relation to those prices. Now, those prices, of course, that data is not in the defendants' hands because the defendants are responsible way up the supply chain for the deep sea fishing. But they do have Mr. Goss, who they have as an expert witness, industry witness. And Mr. Goss's position, the reason why he is able to give expert evidence is precisely because of his position working for, I think, the third largest motor retailer in the country. So they do in principle have access to that kind of data, which is what we say is the kind of data they need to be looking at in order to estimate loss.
And his position is that the delivery charge is passed on in full.
My lord, yes. So their position is that, but we say that that's inherent in that is the error, because this is what I'm going to come to elaborate on, but we say inherent in that is the error, because, and that's why we say, in fact, the question is obscured by thinking about pass-on, because the starting point is, did this cartel cause a consumer to suffer loss? They've only suffered loss if they've paid more than they would have paid absent the cartel.
Yeah, your point essentially is that the car is a composite product.
Yes.
Made up of all sorts of different bits and pieces. And just because one piece of the car, say tyres or windscreen wipers, has been inflated, it doesn't necessarily mean that the price of the whole car has been inflated.
That's exactly our point, my lord. And I will say...
Well, that's even I can understand.
My lord, I'm grateful. I will say that point, if you will indulge me, in a number of different ways to try and to try and explain it as well as possible. But I'm not there yet, so if you'll bear with me. But I'm very gratified that you understand our fundamental point, and it's a short point, my lord. It is a short point. Now, our response, supplementary bundle tab 2, starts at page 55. I just want to take you to page 61 of the bundle. And really the point is that we squarely raise this point on the pleadings, the point that we're making now in this appeal. We squarely raised it in the pleadings.
65, did you say?
61.
61.
Yes, paragraph 22.
Yes.
And if you could just read paragraph 22. And once you've read that, if you could move on to page 68. Paragraph 43, this is where we elaborate on that point. So we say, second fundamental flaw in the methodology is that it analyses only delivery charges, not the prices paid by consumers, by class members for their vehicles. Even if the methodology could establish that delivery charges were higher in the real world than in the counterfactual, which it can't for another point we ran below, which we're not reprising on appeal. That would not establish that PCM's class members suffered loss. They could only have suffered loss if the overall prices paid for their vehicles were higher in the real world than in the counterfactual. That's a different question to the question addressed by the report's methodology. In particular, if the actual delivery charges were higher than in the counterfactual, but the basic price or the negotiated price of optional extras were lower, the net effect may be zero, or at any rate lower than would be suggested by the BDO report's methodology. So that's our point. And then if you go to page 71, paragraphs 53 to 55, which I'm not going to read out, I'm simply going to say that what we said there is that translates into two things. That error means that there's not a plausible methodology within the meaning of the Microsoft test, and so the proceeding shouldn't be certified. And secondly, that we have a strikeout claim because the claim as pleaded is not reasonably arguable. And those are the two legal arguments we continue to make on appeal. Now, how did the class representative reply to this? Their reply is behind tab 4, and within that tab, if you could turn to page 162 of the bundle, please. So halfway down page 162, you see a heading, delivery charges are the appropriate focus of the pass-on methodology. And if you look at the end of paragraph, at the bottom of the page, the last sentence at the bottom of that page, the starting point. So they say, well, this is a cartel about deep sea carriage services. The starting point, therefore, is that the loss caused to the proposed class is represented by the difference in price they paid, albeit indirectly, for those services, i.e. for the shipping of their vehicle. As explained above, that can be accurately assessed by looking at the delivery charge, which reflects the actual cost of delivery of a new vehicle. In contrast, and this is really critical, there is no causal connection between the tortious conduct of the respondents and the overall price which a proposed class member paid for their vehicle. The overall price paid is the function of a negotiation not between the proposed class member and the respondents, but between the proposed class member and a third party, i.e. the retailer or dealer who sold them the car. There's no basis for taking into account a discount given by such third party unless it was in some sense caused by the respondent's breach of duty. And that's the Fulton shipping point. Indeed, you see Fulton shipping footnoted at footnote 4. So this is why this is a question of law. What they're saying is, you're wrong, appellants, to say that the correct focus of the damages inquiry is the overall price of the cars. It's really about the shipping service that the consumers have purchased. Of course, we say parenthetically, no consumers purchased a shipping service. These are cars which are in the United Kingdom, many of which haven't even been shipped. But they say that's what they're paying for. And anything else that's involved in making up the price of the car, which is the only thing, after all, that the class members are paying for, anything else is an extraneous benefit which falls to be discounted under Fulton shipping. So that's their answer, and it's a legal point.
Just looking at the relationship between paras 69 and 70. 70 is an answer. Is it the only answer? Or is the answer also found in 69 that the pass-on is passed on? And that's, in a sense, it's their response to you saying that there was negotiation which erodes it away or which it can't be proven. They simply say, well, if so, so what?
My lord, it's one and the same point, really, on proper analysis, we say. The reason they say that it's been passed on is because they say that that anything else is an extraneous benefit. And so, but we say you can't say, it's not a severable cost. It's not like, if I can put it this way, and I'm going to come now, I keep saying I'm going to come to elaborate on my submission, I'm going to do that in 30 seconds, but before I do that, if I can just put it like this, if you go into a local wine merchant's and you buy a bottle of Burgundy, you're buying a bottle of Burgundy. Now, it's been shipped from France, but you're not paying for a separate delivery charge. You're not paying for a delivery service. You, as the consumer, you're buying a bottle of wine. Now, it might be that the wine merchant internally accounts and wants to recover its delivery charge. So in its accounting, it might say, right, well, we're setting the price fully to take account of the delivery charge. But that isn't what the consumer's paying for. Now, it might be that the effect of the...
why isn't it what the consumer's paying for?
Because, my lord, it may be because the consumer's paying for a bottle of wine.
Yeah, but it's paying for a bottle of wine in the shop. And
That's right.
It doesn't get there of its own accord. Part of the cost of getting it there is transportation.
My lord, yes. And it may be, for example, that the wine merchant says, well, we want to recover all of our costs, so our costs are higher than they otherwise would have been, and we have this set profit margin that we want to achieve, which is 5% or something. Let's say this is our profit margin, but we're going to put that on top of all of our costs. In that case, there wouldn't in fact be... In that case, then what would have happened is you would see the delivery charge come through to the final price paid by the consumer. But what happens if the wine merchant says, well, shipping costs have increased this year because of Brexit or for whatever reason, but we're actually competing now against English wines that are suddenly booming. English wines have become a lot more popular. So we are going to carry on recovering our costs, but we can't afford a 5% profit margin because we need to keep the retail price competitive with the English wine, which is suddenly doing a lot better. So we are going to put a 4% profit margin on top. Now, in in the class representative's sense, the shipping cost has been passed through, but it hasn't resulted in any loss to the consumer, because the wine bought by the consumer is no more expensive than the wine that they would have bought had it not been for the shipping cartel.
You've described a factual scenario under which the pass-on has been eroded away because of internal controls. Isn't the answer to that might or might not be correct? It's a matter for trial. You may be right. You've got a compelling analysis, but the CAT didn't actually believe you at this stage.
My lord, that doesn't work. Can I explain why? Because they haven't pleaded that case. So they haven't pleaded or put a methodology in place to demonstrate that the overall price is higher. So had they said, we accept that you need to look at the overall price, but whether or not it's higher, what companies do in terms of profit margin is for trial, we accept, we wouldn't have a point of appeal.
Yeah, you really focus on their paragraph 70, where they say that the overall price is irrelevant.
My lord, that's exactly right. And so paragraph 70 is the key focus of our appeal. It's a simple point, and their methodology is designed to estimate the loss that they describe at paragraph 6970, which is not the loss we say that matters. So to my Lord Justice Green's point, there are undoubtedly lots of matters which can be thrashed out at trial on which there'll be disclosure. But when you haven't pleaded the case in the first place, none of those are going to see the light of day. And one can, in a sense, test it this way. On their pleaded case, what if we sat back and said absolutely nothing? And we then have a trial. We then have a trial about the increase in the delivery charge. Then the court won't know whether that led to, there won't be disclosure, no one will find out whether that actually led to an increase in the overall price or not. So on their pleaded case, you never get to the critical part of the analysis. And that, my lord, is why it's not a question of fact to be left till later. The act of certifying and not striking out this claim is that we're all going to proceed to trial along the wrong track, looking at the wrong thing, and we'll never get an answer to the question that's correct.
Certain. We know what your case is. The CAT knew what your case is because they summarised it. They took the view that if you were right, they would make adjustments at trial. So the issue was live.
It was, and I'm going to show you where the CAT went wrong.
Let me just put this to you. This certification is a very early point.
Yes.
The issues have now been canvassed in the judgment. There will be disclosure, witness statements, expert evidence. And using normal case management powers, the CAT will reduce everything to its bare essentials, require the experts to identify issues.
Yes.
Your case is as set out. You may be right that pleading isn't perhaps as pellucidly clear as you say it should be, but the CAT didn't seem to think that was a problem. And I'm not certain why this will necessarily be a problem as the matter proceeds to trial. I mean, we all know what the issue is. You very clearly articulated it. I'm just trying to understand why this will necessarily cause a problem later on.
My lord, it's a good question, and I am going to grapple with it. So when you say, just pulling that apart a little bit, when you say we all know what the issue is, well, our first point, of course, is my Lord Justice Lewison's, the point that my lord just put to me, which is, well, that isn't the case that the other side have articulated. So we may say we know what the point is, but they're disagreeing, and that is a point of law.
You say they've foreclosed an essential line of inquiry.
Exactly.
And they've done that in paragraph 70 of their reply.
Exactly, the essential line of inquiry. And then returning to my Lord Justice Green's question, why can't this all come out in the wash with disclosure and the factual inquiry at trial? I am going to take that in stages, with respect, if I may. So I'm going to look at what the tribunal said, because you're right that the tribunal said, well, there's this, that, and the other fact that's been pleaded, that if that all comes out at trial, as the class representative says, it doesn't matter. And we say that's why we're here, that's the error, that part of the tribunal's judgment is where it went wrong. But I'm going to take that in a little detail, but I appreciate I have to grapple with that point. So standing back, we say, let's assume in the class representative's favour that, first of all, so I want to assume various things in the class representative's favour. First of all, the cartel led to an overcharge in the shipping costs, point one. Point two, the shipping costs, including the overcharge caused by the cartel, are passed on in full to the retailers. And three, that the retailer includes in its invoice to the customer and in its internal accounting a line item that is equivalent to the average cost of delivery for the relevant brand and is labelled delivery charge.
Why do you have to see? I thought we established earlier on it doesn't matter whether they do or don't have a line.
No, but I'm assuming their best case in their favour.
Okay. But in fact,
it doesn't matter.
If it's part of the on-the-road price.
Exactly, it doesn't matter.
Okay, so that... Right.
I take that point. So, but what we say is that, and you have our essential point on this, that doesn't amount to pass on of the overcharge or to the class member suffering loss unless the total price for the car is higher than it would have been absent the cartel. And we say that because class members haven't purchased a delivery service. The shipping costs incurred by the manufacturer and the overcharge on those shipping costs are one of many costs that the manufacturer incurs in the course of manufacturing cars and getting them to the retailer.
Just so I understand, and going back to a bottle of wine type argument, and your 4 and 5%, if a customer faced with a price, whether it includes a delivery charge line item or not, negotiates a proportionate discount, 10% off, why won't they be paying more than they would have paid if there hadn't been overcharging on one of the items that made up the composite price? Because they're necessarily just getting a proportionate discount, but from a higher initial base.
My Lord asks a very good question, and if I may, in answering it, just distinguish between 3 types of negotiation. So starting with the type of negotiation my Lord has just put to me, if you're negotiating a discount, so say each time you say, right, I want 10% off, then you're right, my Lord, subject to a different point about the list prices, which I'll come to. You're right that that would entail some, but not all, of the delivery charge being passed on. But of course, pausing there, their case is premised on all of it being passed on because you don't look at that stage. So their case doesn't examine the amount, they don't examine whether all or part of it's passed on because they stop short at the delivery charge and they say none of what happens afterwards matters. Now, take a different case. Let's say that instead of negotiating for a 10% discount, you say, well, this car is £20,690. That's its list price. I'll take it if you give it to me for £20,000. A nice round number. And let's say that that is what the consumer would have done regardless of whether there's a £3 or £13 overcharge on the delivery fee. So they would have alighted at £20,000, whether it was 20,690 or 20,710. Then in that case, none of the delivery charge would have been passed on. None of it. Because in the real world, with the cartel, where the price is £2,710, they would have said, give it to me for around £20,710. They would have said, give it to me for around 20,000, round number. And in the counterfactual world, absent a cartel, where it's, say, £13 less, they would have done exactly the same thing. Now, if that's the case, for those types of consumers, then there would be no pass on at all of the overcharge, because what they're doing in the factual and the counterfactual is exactly the same. They haven't suffered any loss. And that really illustrates why this point matters and why, on their case, you never get to analyse this kind of question. I think what
you're saying in answer to my Lord's question is that there might or might not be an abatement of the delivery charge. It depends on exactly what happens at the consumer end.
Yes.
And unless you inquire into what happens at that end, you will never know.
My Lord, that's exactly.
So we're back really to paragraph 70.
My Lord, exactly. My Lord, yes. So Mr. Pitchinin says it's not just paragraph 70. That really encapsulates it, but it's that they haven't advanced a case to say. Now, my Lord, you've seen that they assume that there's 100% pass on of the delivery charge to the final consumer. So they say, well, look, everyone's seeking to recover the delivery charge. It appears in the same form in the invoice, so that's it. That's 100% pass on. But I just want to explain why we say that it can't be assumed, just as a matter of logic, that you would get 100% pass on in a case like this. And there's normally trials precisely to decide exactly how much pass on there is. And that's because, as in my wine example, where you've got the competitive force of the English wines that are now coming up, in this industry too, car manufacturers are competing with one another on price. And so the manufacturers who produce cars outside the EEA and incur these shipping costs need to compete with the excluded brands like Fiat and Volvo, which don't use the Ro-Ro services at all and don't incur those charges or those overcharges. And the illustration we gave in the tribunal below, which is then reappears, is reflected in paragraph 119 of the judgment, refers to the BMW X5, which is a high-end SUV, which is manufactured, as it happens, just in one factory in the world, in South Carolina. And now, no doubt, we don't know what those reasons are, but no doubt BMW had good reasons for locating its manufacturing facility in South Carolina. It may have got tax breaks, we just don't know what the position is. But that decision will have led to higher delivery costs for the BMW X5 in the UK, to the UK, than if they'd been manufactured in the EEA. But when the BMW retailers sell the X5 in the UK, when they set the on-the-road total list price, or when they negotiate discounts with consumers from that price, they need to be competing, they need to be competitive with similar vehicles produced by other manufacturers. So for example, the Audi Q8 or the Land Rover Discovery or the Range Rover Sport, which are all excluded brands which don't incur that cost. So the BMW retailers need to set prices that are competitive with those vehicles. And so the Ro-Ro prices might rise, but those price rises may not affect the price for the vehicle given the competitive forces. They may or may not. That's a question that we say would need to be determined at trial, but won't on their case.
I think, if I may say so, I think that part of what you're saying, if I've understood correctly, is that you shouldn't get bogged down with all this competition jargon about pass-on.
Yes.
The question is, there has been a tort committed. What loss has that caused to the victim of the tort?
My lord, that's exactly our point. And the use of the competition jargon of pass-on is obscuring that fundamental point. And so what's happened here is that the tribunal set off has allowed these proceedings to go forward in a manner which the tort hasn't been pleaded adequately.
Well, the tort has been, but the damage has.
The damages.
What are the implications of this analysis upstream? Are you saying, therefore, that the first purchaser, let's say the car manufacturer who picks up a vehicle at Felixstowe, has a claim for 100% of the overcharge, even if they've passed it on?
No, my lord,
So
no.
nobody's got any claim at all?
No, of course not. So that downstream pass-on, if you mitigate your loss by passing... So in this case, there'll be a question as to whether the consumers, which include businesses, so they're included businesses that purchase vehicles, there'll be an issue for another day if this is certified, as to whether or not the damages which they claim are reduced by pass-on downstream from these. But that's a question for another day. We're not saying that's not the issue that we're raising here.
So if there has been pass-on, the first purchaser, the manufacturer, the vehicle seller, has no loss, so can't make a claim. If then somehow it becomes smothered in the final price, the consumer has no claim. How does that square with what the tribunal said at 125, which was a finding of fact, well, provisional, obviously very, very provisional and tentative, which was that the delivery charges are considered to be separate cost items, which must be recovered. So even though it may be embraced in a single price, the CAT seems to assume that an element of it does reflect delivery. But of course, from our point of view as consumers, we have no idea how the costs are put together or what the seller's negotiating strategy is. But it seems to be that from the seller's point of view, you will negotiate, of course. Either that negotiation is done on that 99% of the price, which is unrelated to the delivery overcharge.
Yes.
Or if there is a negotiation, well, I mean, I'm just looking at what they say as a fact. It is passed on.
Well, my lord, that's where we say I am going to deal with this in stages, the tribunal's judgment, but that's where we say they went wrong, because what they're doing there is, in a sense, siloing the delivery charge and saying, well, that represents the loss, and because of our fundamental point, we say it doesn't, because of the point that money is fungible, and you don't have. It may well be that a manufacturer and the NSC seeks to recover all of their costs, but whether that leads to loss on the part of consumers.
Well, I think they're saying it's not that it is siloed, but there's two silos. There's general price and then there's delivery. Well, I suppose we're looking at the supplier's mentality here.
Yes.
So what the tribunal finds is that it says the applicant's industry expert evidence is it's highly unlikely for OEMs and NSC, so that's the supplier,
Yes.
not to recover delivery costs in full, and rare for a retailer to discount the delivery charge, there being no customer expectation to do so.
Yes, my lord. So this is all looking at their case. It's premised on their case, which is pass on equates to the delivery charge reflecting what the cost is. The delivery charge in the either in the invoice or not in the invoice, as my lord says.
Albeit concealed in some way within an overall
yeah,
price.
so it's premised on their case. So what the tribunal's saying is, yes, they've claimed pass on as a matter of fact, but then one needs to ask, well, what do they mean by that? What they mean is that the delivery charge itself hasn't been specifically negotiated away, to which our answer is, well, so what? Let's assume that. It doesn't take you any further.
Sorry, wait a minute. I mean, I thought the evidence, putting it sort of simplistically, what paragraph 125 is saying is that whether correct or not have to wait to trial, but there is at least evidence to suggest that the increase in shipping costs will at least get to the dealer stage, i.e. the delivery
That's
charge
right.
as requested by the dealer.
Yes.
I mean, you criticise that separately from the question about whether you still need to actually find what did the customer do with it. You know, what did the customer negotiate?
No, my lord. So let's look at paragraph 125 since we're on this. So what you have.
I think your complaint really is the last two sentences of that.
Yes.
Because what you've been saying to us is that we won't be tested at trial because that line of inquiry is simply not part of the case.
My lord, yes, exactly. And so, and it's not part of their pleaded case. It's not a question, as my lord put it to me a little earlier, that you can't be too harsh at the certification stage because disclosure will be available later. Disclosure on the pleaded case.
Well, hang on.
This is not
I'm sorry, I thought it would be part of their case insofar as it is pleaded to dealer level.
My lord, yes.
But not that. I think your criticism actually it's not part of their case, as it were, between the dealer and the customer, but it is part of their case, I think.
My lord, can we go through
all
it
the way
sentence
down
by
to the dealer?
sentence?
Is that
yes,
right?
that's right. So if you look at paragraph 125, they say, I'm now third sentence, the applicant's industry expert evidence is that it's highly unlikely for OEMs and NSCs not to recover their delivery costs. That's, my lord's right, that's from the dealer. So the NSCs then send it to the dealer and they seek to recover their delivery costs. Now let's assume that's correct. We're not seeking to challenge that
You
for
don't
these
challenge that,
purposes.
It's the
Let's
next
assume
bit.
that's correct. And then rare for a retailer to discount the delivery charge. Now let's say that's correct, because that's not looking at discounting the whole car. That's looking at the delivery charge line item. So let's assume that's correct. There being no customer expectation to do so. So if you have a delivery charge line item for those brands that do it of £500, let's accept for now that isn't specifically negotiated away. So we're content to accept that. This is where it then goes wrong, or where the tribunal then goes wrong. Importantly, the evidence of the industry experts is that delivery charges are considered to be a separate cost item which must be recovered. We say, well, so what? In other words, they're not simply wrapped up in or considered as part of a single undifferentiated price, but are considered separately. And that's where we say the error of principle has been made by the tribunal.
Sorry, can you add, for my benefit, identify which, as it were, delivery charge and which entity in the chain is being referred to in that sentence?
Yes.
Because point is delivery charges are used both to cover the costs, as it were, higher up the chain, as well as at the end of the chain.
Yes, and so, my lord, so what's being talked about at this stage? So we've dealt with the position up to the retailer, that's the OEM and the NSCs recover their delivery costs in full. And the delivery costs will include, but are not limited to, the deep sea shipping charge, which may or may not be incurred on particular vehicles. It's all averaged and spread into the cost. So that's recovered in full from the retailer. That's what's being said. And we're content to accept that for these purposes. Then they say, we're now at the retailer stage, vis-a-vis the consumer, if I can put it that way. What's being said is that the specific delivery charge, where there is one on the invoice, is not negotiated away, is not the subject of a discount. So where the invoice says £500 of this price of the car is for delivery, that £500 is not specifically negotiated. To which we say, all right, well, we'll accept that for these purposes too. It doesn't help. It doesn't help resolve our fundamental difficulty. And then the last part is where the tribunal goes wrong in our submission. So they say that that because of that allegation, which is that it's a separate cost item which is sought to be recovered, that therefore...
Which must be recovered, not sought.
Well, which must be recovered. But, my lord, it doesn't matter. In the same way that the seat belts, that must be recovered too. So all manufacturers seek to recover their costs. The question is, if those costs rise, do they charge the consumer more? They may or may not, depending on what their... That's really the point. And none of this, the tribunal is getting that wrong. It's in those last sentences.
When they say must be recovered, if you've got a situation whereby the cartel supplies to the vehicle manufacturer and it's all in-house, it's a within group, right the way down to the consumer.
Yes.
Then the notion of must be recovered can only be must be recovered from the consumer.
My lord, yes, but then the next question, so I'm happy to accept that. So let's say there's a rule in the company that says we're not allowed to price unless we recover our costs. And what that means is that they will seek in the price they set to recover any overcharge from a cartel. That doesn't answer the question, and the reason why it doesn't answer the question is because, of course, what's charged to the consumer is an amount which seeks to recover the costs. Yes, we can take that as read on this hypothesis, including raised costs, but also seeks to achieve a profit. And the question is that price higher because of the elevated costs? And that's that's the point that they never get to. They stop short of that point. And so
is that fair? They've set out the class case here. They set out your case, and then they say whether that is correct or not, and whether delivery charges are discounted in other ways. And the correct or not is whether they are considered separately, is for trial. Doesn't that encapsulate the dispute between you and their recognition of it?
My lord, no. Can I say why? It's not for trial, and again we say it's not for trial because that's not their case. They don't have any case that.
Okay, I understand that. I mean, there's maybe a separate point, which is a pleading point as against to what evolved during the certification hearing and what the CAT thinks of the issues. Let's assume they've been very naughty and haven't drafted as clearly and as fully as they ought to have done. Does it matter as a matter of principle once the CAT has listened to argument, identified and crystallised the dispute and says, at this stage we tend to prefer the class analysis of facts, but we absolutely understand that they may be wrong?
My lord, it does matter. I think it's going to be easier if I do take it in stages through the tribunal judgment rather than just jumping to the punchline on this. I've almost, if that's all right, it won't take me very much longer. So just to finish, and I know you have our point on the I know you have our fundamental point, but can I just coming back to a point put to me by Lord Justice Snowden, can I just distinguish? I think it's helpful to separate out list prices. It's helpful to think about both the overall on-the-road list price for a car and subsequent negotiation. And this is just going back to the point put to me by my lord, because the overcharge may or may not be reflected in the overall list price by the retailer for the car because of the operation of competition in the market. And this is my point about the BMW. So they may recover their costs, they may recover the overcharge, but the price, the end price may stay the same, which means a little bit less profit because of competition in the market. Or it may not be either or, it may be in the middle. So there may be some pass on, but not complete pass on. And so that's so, we say, even if the notional line item in the invoice or the hypothetical delivery amount where there is no separate line item in the invoice is the same in what's being charged to the consumer as it has been all the way upstream, which is the factual point that the tribunal is referring to at paragraph 125. So even if it is the same, the NSC may have recommended and the retailer may have charged a total list price for the car which is the same as they would have charged absent the cartel because of the need to compete on competition in the market. So that's the point we make about list prices. Separately, it's common for purchasers to negotiate downwards from the list price, and that will also affect the question of whether the overcharge is passed on. And I've really explained this in the exchange with my Lord Justice Snowden, but by way of illustration, as we've said in our skeleton argument, the class representative estimates that the cartel inflated the delivery charge line item for Volkswagen cars by as little as £3 in some years and £14 in other years. That's the range. So let's say that a customer negotiates over the purchase of a Volkswagen car with a total list price, including delivery charges and other on-the-road charges, of £20,000, £955. That's the price that's being presented. And they ultimately agree on a final purchase price of £20,000. So they say, well, you've got it for £20,955. We'll take it. We'll buy it if you bring it down to £20,000. There's no basis for assuming that in the absence of the cartel, where the delivery charge might have been, say, £3 or £13 lower, that the customer and dealer would have instead agreed on a final purchase price of £19,987. You see how the argument works. Indeed, we say that might seem rather unlikely because it's more intuitive to think that at least some customers do negotiate in that way in terms of achieving a round number. And of course, if they would have still agreed to the same round number with or without the cartel, then they haven't suffered any loss. Now, as my lord put to me, it's a bit different if you're negotiating on a percentage discount. In that case, there'll be some but not complete pass on. And if you're instead negotiating in both the real world and the counterfactual world, seeking to achieve a particular figure, say, well, I want £500 off, I don't really care where that takes me, that's what I want off, then they would be paying more for the car in the real world with the cartel than they would have done in the counterfactual. So it all depends on how you negotiate. But if the parties do anything other than negotiate in that we want £500 off, then the negotiation will mean that the overcharge is either not passed on at all or not fully passed on, even if the delivery charge line item is exactly the same. And so, as we say, these questions, had the claim been pleaded properly, would have had to have been investigated at trial. Now,
so can I just ask you, when the tribunal said we can make adjustments at trial, let's assume that you have a global price. Presumably, what the tribunal had in mind was to take, as it were, a percentage of a percentage of a percentage. You can work out the overcharge, you can calculate it as a percentage of the final price, and then you can apply that percentage to the discount achieved through negotiation in order to pro rata throughout the process what the ultimate negotiated loss would be.
but then,
Discounted loss would be.
on their view, you never get the final price of the car. That's the problem, because they say they've disavowed that as being relevant. They're not seeking any data as to the final price of the car. And that's really why this is such a fundamental point. Can I take you to the tribunal's judgment now? That's what I was going to do next, just to go through the steps in the reasoning. So, if we can pick it up from page, so we're behind tab 11, and if we could pick it up from page 174. where you see the heading overall price versus delivery charge. And then you have our submissions, which are the same submissions as we're making to you, substantively the same submissions. We have those summarised at paragraphs 114 to 115. And then, just as we're going through it, just to see the structure of the reasoning, at 116 to 117, so I've made the point about the BMW and having to compete with others, and the final price might be no different. And I'd made it by reference to the Commission pass-on guidelines, which talk about producers of orange juice and having to compete vigorously, and therefore the final price might be the same. And what the tribunal's saying at paragraphs 116 and 117 is, yes, but cars are not the same as orange juice, and so it may be different. So there may be more pass-on for cars than for orange juice. And again, we're perfectly happy to accept that that might be the case. That isn't the fundamental problem here. What we're saying is that that is indeed a question that would need to be investigated, but will never be investigated on the case put forward by the class representative. So we're not, to put it another way, we're not seeking to strike out the proceedings because because we say there can't be any pass-on at all. Of course we're not saying that. We accept that there might be pass-on the facts. They've just gone about it the wrong way in terms of the pleading and the methodology. Then we see over the page at paragraph 120 what the tribunal describes as the respondent's primary response to our argument, and that's the legal submission made on Fulton shipping. The argument was that any negotiation between class members and retailers involves benefits conferred by a third party and shouldn't be taken into account. And that was the point. That was the point we saw at paragraph 70 of their reply. And then we see at 121 to 124 the tribunal correctly rejecting that response. And so at 121 we have the key point that there are not separate transactions. So no separate transaction or event of the kind considered in Fulton shipping, because class members entered into single transactions to acquire the vehicles. So we say that that's correct. Then at 122, the tribunal rejects an argument based on the Supreme Court in Sainsbury's, which they correctly found doesn't assist the class representative, and we agree with that. I'm going to come back separately to deal with Fulton and Sainsbury's, but I'm just showing you the structure of the judgment at the moment. And then 123, the tribunal, if we look at the second sentence, so however, if it was the case that pass-on didn't occur because discounts were negotiated or list prices were set in a way that would have differed in the counterfactual as opposed to the actual, such that any overcharge was not passed on and was passed on to a lower amount, then it's likely the claim would be affected. So there, the tribunal is accepting our point, our legal argument. So they're accepting that it matters to look at the overall price of the cars, whether or not the list price would have been any different, and what the effect of negotiation would have been. So far, so good. They're accepting the principle of our point. And then at 124, you can see the response of the class representative. The applicant submitted that this could only be demonstrated where the customer specifically negotiated away the delivery charge, and I emphasise those words, which the industry expert evidence indicates would be a rare occurrence, rather than achieving a discount on the overall price. So they've again put their argument, which we say is legally wrong. They say you don't look at the overall price. All that matters is whether you're negotiating away the specific notional delivery charge. And the tribunal rejects that, saying it assumes the answer to the question whether list prices or any discounts on the overall price were affected by the cartel. So we say that's absolutely right, and that's consistent with our argument. And we say, pausing there, the tribunal's with us on the principle of the matter. So what the tribunal should have done is then struck out the case and or refused to certify it because there was no plausible methodology. But then you have 125, where the tribunal says that questions of causation are fact-sensitive and finds that the methodology relied on by the class representative offers a realistic prospect of establishing loss on a class-wide basis. Now, pausing there again, the tribunal doesn't address our strikeout argument here. It's really dealing just with the methodology. In other words, it doesn't address our allegation that no proper claim has been pleaded. And more than that the class representative has positively disavowed in its pleadings any causal link between the cartel and actual transaction prices. But leaving that aside for the moment, what the tribunal then does is refers to a number of factual matters, factual allegations made by the class representative, and says essentially, well, if these factual matters hold good, then it doesn't matter. Presumably, they think it doesn't matter because they say if these factual matters hold good, then the overcharge in the delivery price, there'll be no difference between the overcharge and the delivery price and changes in the overall transaction price. But we say this is where the tribunal's made an error, and really it's for the points I made previously, that if you assume all of these factual points in the favour of the class representative, so pass on up to the retailer, tick, no negotiating away of the specific delivery item, tick, we assume all of this, you're still not confronting the fundamental flaw. That's really the problem with all of this. So if you look at, I've dealt with 125, but if you look at 126, further, as Mr. Robinson points out in Robinson 2, the negotiating characteristics of the parties are the same in the counterfactual and actual scenarios. Again, let's assume that that's true. Let's say propensity to negotiate is the same in the actual and the counterfactual scenarios. But it doesn't tell us anything about loss in the individual case, because as I said previously, if a consumer would have negotiated to reach the £20,000 purchase price, whether or not the delivery charge was £13 higher, then there's no loss. You might think that the fact that these overcharges are so small, in some cases we saw for Volkswagen £3, that's a reason to think that it's unlikely to have to be any difference in the factual and the counterfactual in terms of arriving at the same round figure during a negotiation. Then if we go to 127, the tribunal's there saying that there was no evidence before it as to how list prices were set and whether discounts would have differed in amount in the counterfactual. Again, we say, well, on the class representatives case, there will never be any evidence on that because they're saying it's not relevant to look at it. But then they say, if you go to 179, that the evidence does unsurprisingly suggest that discounts could be negotiated, particularly by large business customers, and also that the delivery charge element may not be immune from negotiation. And again, we say, well, that doesn't take us any further because if it's not negotiated, we can assume that, but it doesn't answer the question.
Sorry, did you say 179 or 129?
127, I'm so sorry.
No, sorry, 127, and after that you gave another paragraph number.
No,
that
it was
127?
page
That was
number.
the page number.
Page number.
179, paragraph 127 and page 129.
Got it, thank you very much. Sorry.
But you don't really quarrel as a matter of substance, do you, with what the CAT says in 127? Your complaint is that adjustment will never be made because of the way in which the claimants have framed their case.
My Lord, yes, so at the end of 127, the CAT's recognising our point, the force of our point. But that's contrary to, that's proceeding on a different basis, different principle basis to the basis on which the class representatives proceeding. So that's not how they've pleaded their claim. They haven't said, right, you need to look at, we accept that you only measure loss by looking at the total prices. And we don't have all the data, but we'll get it by the time of the trial. So we're not in that world. If we were, we of course realise that the expert evidence at this stage is not a counsel of perfection and that things change up till trial and that there's disclosure and so on. But it's much more fundamental than that. They have not only have they not pleaded a case based on total transaction prices, but they've disavowed that is the relevant measure of loss. And so the basis on which their evidence proceeds is flawed, fundamentally flawed. Now,
if their pleading matched what the CAT was describing here, would you have an objection?
My lord, there would need to be... So I think what you're putting to me is...
Well, I mean, it boils down to this. Is this an objection to pleadings, given where the CAT's got? And we know that things obviously developed. There was a very sophisticated argument in front of the CAT. Is this really a criticism of the pleading or the CAT's judgment? Or are you saying the CAT should not have accepted this analysis because it wasn't properly reflected in pleadings?
My lord, it's not just a technical pleading point, because the difficulty is that the case that's pleaded is the basis on which they adduced all of their evidence before the CAT. And so, for example, there was no evidence before the CAT from Mrs. Goss and Whitehorn on how list prices were set, or how, whether or not...
Yeah, they say that in paragraph 127.
Yes, and so it's not a case... Let's say, for the sake of argument, they had come to the tribunal and they'd said, well, we accept that the right measure of loss is you have to look at the total transaction prices. But we think that's going to be terribly difficult because we're not going to be able to get that data. So we're proposing a methodology that instead looks at the individual delivery charge item. But we accept that that's not the end of the story. It can't stop there. So here's some factual evidence or expert industry evidence from us saying that when list prices are set, they're never set with regard to competition in the market, because the NSCs always seek to achieve a set 10% profit margin or whatever, and that when it comes to negotiation, it's hardly ever the case that people negotiate on percentage terms or to achieve a round figure purchase price. It's always the case, or 70% of the time the case, that people say, I want £500 off. So actually, it doesn't matter that we're not going to look at prices. Now, had they done that, then of course the tribunal would have had to have scrutinised that evidence, and the debate would have been, well, does that evidence stack up? Does it look plausible? But critically, it might have looked like a very different type of claim. So had Mrs. Goss and Whitehorn said, well, actually, we think that that 50% of the time customers do negotiate, it's only 50% of the time that the customers negotiate in the way they need it to be, which is the £500 flat fee, then they would have had a claim for 50% of the loss that they're claiming. And so when looking at the other certification requirements, like cost benefit and indeed the funding arrangements, the tribunal would have been analysing the claim on a totally different premise. But they haven't done that. They've said, no, that's not how we're doing it. We're doing it like this. We're claiming all the loss, and you only need to look at the delivery charge. And that's why it's not fixable, my lord. That's why it's not a case of saying, oh, well, we can fix the pleading and they can bring more evidence in at trial. There's a fundamental hard-edge problem with the way that they've pleaded the case. We're not saying, of course, that it would have been impossible. So look at Merrick's. Merrick's is a claim in which that the class representative has had to plead and formulate a methodology to prove that very small increases in interchange fees paid by retailer banks to cardholders' banks affects the price that retailers pay to their banks for banking services, which then in turn affects the price that retailers charge for all sorts of goods and services across the customers to people that buy those goods and services, so most of the population in the UK at the relevant time. Now, that's not an easy task, but of course it was certified because there are well-established tools for carrying out the task, and because it's accepted that a broad axe can be wielded and that problems with data availability can be overcome. But we're not in that world. Here, there is a hard-edged fundamental problem with the way the case has been pleaded, which is that they're looking at the wrong thing. So what that means is that the court has before it a pleading which is not only defective, but it doesn't contain the minimum factual averments, factual allegations that are needed in order to make good the claim. So there's nothing about, well, this is how list prices would have been set, this is how negotiation would have taken place. None of that was adduced before the CAT. And so it wasn't able to consider a perfected claim. They knew what point we were making.
You've made the assumption that such evidence is available. I mean, the CAT, I mean, I can't remember, it's in the paragraph 70 or 70, in the early 70s, they made the point that there are cases where we will have to accept a second best or a third best methodology. they don't. You dispute that as a principle?
No, I don't dispute that at all as a proposition. So had Mrs. Goss and Whitehorn come along and said, we accept that you have to look at, we accept that the measure of loss is the difference in price of the cars. We're doing it this way, but we accept that in order to make good our methodology, we have to show you how negotiation takes place in practice and how list prices are set, and that it's done in X way rather than Y way, or rather X way, X proportion of the time. Had they come to do that, we wouldn't have been able to challenge it at the certification stage or at the preliminary stage. It would have been a matter for trial. But they've just gone off on totally the wrong tangent. Can I look finally at what
I'm sorry, I just want to make sure I understand your...
Yes.
The middle of 125, when the tribunal says it's highly unlikely for OEMs and NSCs not to recover delivery costs in full and rare for a retailer to discount the delivery charge, there being no customer expectation to do so.
Yes, you need to divide the sentence in two, first of all, my lord. Sorry to interrupt.
So I'm looking at the latter bit. Rare for a retailer to discount the delivery charge. That is suggesting that there is a separation and the list price is irrelevant. I mean, that's their finding of fact at this stage, which may turn out to be incorrect.
My lord, no, because that finding, so the tribunal, with respect, I think the only way of interpreting this is that they've got into a bit of a muddle, because what you see clearly at paragraph 123, and in the last sentence or two, as my Lord or Justice Lewison put to me of 127, is the tribunal accepting our point of principle, which is that you have to look at the transaction prices. So they're accepting that point of principle. And then what they're doing at 125 is something inconsistent with that. They're saying, oh, well, maybe you don't have to look at the transaction prices because delivery might not be wrapped in, it might be severable. And so that's an inconsistency in the judgment on which we rely. That's where they've gone wrong, the bottom of 125.
Aren't they just relying on the applicant's evidence?
But what the applicant's evidence is establishing, my lord, is this. So let's go back to it. They're saying...
Boils down to, the dispute between you boils down to severability. Is it severable from the list price as a whole? And here they seem to be saying that the applicant's evidence is that it is severable.
My lord, but only in the sense the applicant means, which is that let's look at what the applicant means. So the applicant means, I'm going to come back to their arguments, but the applicant means that the delivery charge is passed on up to the stage of the retailer. So that's highly unlikely for OEMs and NSCs not to recover their delivery costs. That's from the retailer. Mm-hmm. And rare for a retailer to discount the delivery charge, and I'm emphasising the words delivery charge. So rare to say, well, this is the £500 delivery charge, we want something off that. What they do is they negotiate on the total price.
I mean, that assumes the delivery charge is a separate line item.
It does. I mean, if it's not, it's even more nonsensical, their claim, because it's...
It might be. I mean, this is all based upon the seller's perspective. It's what they negotiate. It's not what the customer has any knowledge or sight of.
My lord, but this is the flaw, because in basing it, it's not just a question of fact, well, this might turn out to be right at trial. Let's assume that all of this turns out to be correct at trial, that what they're seeking to do, the manufacturer and the NSC and the retailer, is recover the delivery costs in full from the purchaser. So let's assume that that's what they do. I'm going to give that a big tick in the class representative's favour. We're not quibbling with that. That's what the tribunal's talking about. There's still no loss if they haven't paid more for their car. That's really our fundamental point, and that's what the tribunal, having accepted it at 123 and at the end of 127, it hasn't. That's where it's gone wrong. In
I'm not entirely sure I understand 123. Is there a not missing? If it's the case that pass-on did not occur because discounts were negotiated in a way that would have differed in the counterfactual, do they mean would not have differed?
Where are you looking, my lord? Sorry.
123.
123.
They say if it was the case that pass-on did not occur because discounts were negotiated or list prices were set in a way that would have differed in the counterfactual as compared to the actual.
No, I think that's correct.
If they would have differed, I think your point is they wouldn't have differed.
We're saying they might not have differed. And what they're saying here is, so they're saying we agree with you. This is, I'm going to paraphrase what we say, that what we think they're saying. They're saying here, we agree with you that you look at the price of the car.
Yeah.
And then they're saying, let's substitute the words, instead of pass on, let's say loss. Because so if it were the case that loss wasn't suffered because discounts were negotiated or list prices were set in a way that would have differed in the counterfactual as compared to the actual, then it's likely that the claim would be affected. And so I think what they're saying is, well, there are lots of double negatives. I think what we take them to say is that if it were the case that, for example,
I would have thought.
right.
I would have thought that what they mean.
I think
you might be right.
I think the proposition should be, shouldn't it, that if the price would not have differed in the real world and the counterfactual, then there's no loss. But if the price in the counterfactual and the would have differed from the real world, then there may be a loss.
My lord, that's
I think there's a not missing.
I think there's a not missing. I think you're right. I'm so sorry. I'd read it differently, but you're quite right. But you have our point. That is the point we make.
Yes, I mean, just because the price of flour has gone up doesn't mean the price of your sandwich has gone up.
No, even though the sandwich seller may be intent and may indeed recover in the price it charges any increases in the price of flour. So they may have a rule that says we are going to recover all the increases in the price of flour. Does not equate to loss unless the bread is more expensive. That's really our point. Can I now briefly, in the time left to me...
I'm not going to allow you to do that.
Sorry, my lord, I'm so sorry.
Just paragraph 123 is conditional. So they're saying if there's no difference between the counterfactual and the real,
yes,
there's no loss. Aren't they saying in 125, but on the facts as presented to us at this stage, there is a difference?
My lord, no, because there was no evidence on that. So what they're saying, when there was absolutely no evidence on how list prices were set, nothing.
But then this is then you've got to tell us this is a dispute of law as opposed to your quibble with their analysis of evidence.
Well, my lord, yes, we say it is a dispute of law and that's our strikeout point, that they haven't formulated loss in the right way. They've erred in law in the way they formulated loss. But then what happens is the tribunal, I agree, what the tribunal is attempting to do here at 125 is say, oh, well, there are all these facts up for grabs. And that's the temptation on a certification. You say, right, it's not for us to decide the facts, which of course it isn't. We don't dispute that. There are all these facts up for grabs. It might all end up in the wash. But our essential point is it won't, because the facts that are up for grabs don't take things any further, because they haven't pleaded a case or adduced any evidence that talks about how list prices were set or how negotiations took place. So it comes back to the point I was making. If they had adduced evidence, if Mrs. Goss and Whitehorn had said, well, all right, the methodology is to look at the delivery charge item, but that's okay because actually the way in the real world that prices were set was only by reference to costs and a fixed profit margin, come what may, however competitive the market was. Then it doesn't matter that you don't look at overall prices for that reason. That's something the tribunal would have then examined. But it didn't have that. It didn't have any of that evidence at all. So what was presented was a methodology which is simply not fit for purpose because it's looking at the wrong thing. We're not saying they couldn't have adduced a methodology that could have worked. We're not saying that this class didn't suffer any loss. We're just saying that it hasn't been, there's a fundamental flaw in the pleading and the methodology. It may be that by reference to the class representative skeleton, I'm just going to run through the points they make, and it may be that this assists.
But your point essentially is that the buyer of a car doesn't really care how the components of the price are made up. What they are concerned about is how much are they going to pay for the car.
Yes.
And that's the one thing that the claimants say they're not going to look at.
Exactly. My lord, that's the long and short of it. That is our point, and I've said it lots of different ways, but that's our simple point. Can I just indulge you? Can you indulge me a little further, just because I just want to turn to the respondent's skeleton argument and see what they say. That's in the supplementary bundle behind tab 7. And if you turn to page 100...
Core bundle, I think. Not
core bundle,
supplementary.
you're quite right, so sorry.
Sorry, can you give that page again?
Page 100, behind tab 7 of the core bundle. So paragraph 23 says that our appeal is misconceived for 3 reasons. Does the court have that? So page 100, behind tab 7.
Yes.
And there are you see there are 3 sub-paragraphs. The first argument seeks to establish that the tribunal did not find that the respondent's case, that the delivery charge line item is the correct measure of loss, is wrong in law. So there's a dispute about what the tribunal found. Instead, it says the tribunal found that the question of what is the correct measure of loss is one purely of fact for trial. Now, you already have most of my submissions on that point. I've taken you to the tribunal's judgment. But it is worth pausing here to look at the facts on which the class representative relies, which we see set out at paragraph 28, starting at the bottom of page 101 of its skeleton argument. So it says it relies on the detailed evidence of the industry experts, which the tribunal found to be plausible, that 1, the delivery cost is generally separately itemised throughout the entire OEM NSC retailer supply chain. So again, we say, right, we accept that for present purposes. My lord, do you have that?
Yes, I'm just sorry, which paragraph are you on?
Paragraph 28, bottom of page
28,
101.
got it, thank you very much, yeah.
So these are the facts which they say means that they succeed, or rather that they have a plausible case at this stage. So the first is that the delivery cost is generally separately itemised. So that's the first point. And we say, all right, we're happy to accept that. That doesn't take things any further. Secondly, passing the cost of transporting new vehicles, including shipping costs, on to the end customer as part of a delivery charge is accepted as industry practice. Again, we say we're happy to accept that, but it doesn't meet our fundamental point, which is that will only result in loss depending on the ultimate price agreed. And third, it would be rare for a retailer to discount the delivery charge, as there is no consumer expectation to do so. Again, we say, well, we accept that too, but it still doesn't answer the question of whether the overcharge, whether loss has been suffered. Then we have, at subparagraph 2, the evidence of Mr. Dent, which was advanced by Mr. Singler's client. And what's said there is that the delivery charge can't be discounted. Again, that's the same point. That's just other evidence on the same point. And in that same paragraph, in the third subparagraph, reliance is placed on the expert evidence of Mr. Robinson that in both the real world and the counterfactual world, the negotiating characteristics of the end customer would be the same. Can we just look at that? So that's supplemental bundle. This is his reply report. So it's supplemental bundle, tab 16, page 438. So supplemental bundle 16, page 438. And it's paragraph 4.47. That's the paragraph that's referred to. And you can see the first line, to the extent, and I emphasise those words, that buyers negotiate to obtain a target amount of discount. An important point to make is that the negotiating characteristics would be the same in the but-for and actual scenarios. This comes back to the point I was exploring with my Lord Justice Snowden, which if they say we want a target amount of discount, in any case we want £500 off, then we accept that there would be pass-on in that situation, subject to the point about the list prices. But there is no evidence, and this really reveals this, highlights this point. He's speculating, he's saying to the extent that they do that, then their negotiating characteristics would have been the same. But there is no evidence adduced by the class representative as to how often that happens and what happens when they don't negotiate in that way, but they negotiate to achieve instead a lower round number or a percentage discount, which obviously would affect the question of whether a loss has been suffered. And crucially, they've produced no evidence at all to establish what proportion of customers negotiate in those ways. So none of these points, and these are the three factual points relied on by my learned friend to say, well, it's a matter about our error. None of these points assist the class representative, because you can assume them all in the class representative's favour, but they would not establish that the delivery charge is the correct focus of the damages inquiry. And if you look at paragraph 29 of their skeleton, going back to it, so core bundle, tab 7, page 102, they say that we failed to engage with any of this evidence, and we've asked the tribunal to accept, despite failing to engage, that the customer pays a single overall price and receives a particular vehicle. But with respect, none of that evidence gainsays that they've summarised in paragraph 28. None of it damages our case or meets our case. That's really our point. Now, the class representative then, I'm looking now at paragraph 30, they then say that if we were right that you look at the overall price of the car because that's what the customer's paying for, tort law would always require damages to be calculated by the overall profitability of a claimant. And they say, well, that was rejected by the Supreme Court in Sainsbury's. But Sainsbury's doesn't help the respondent. In fact, it supports our case. And can we just take it up? So it supports our case that a claimant's measure of loss in a competition damages case is the extent to which they've paid more for what they bought than they would have paid in the absence of the infringement as a matter of basic tort law. So if we pick up the first volume of the authorities...
First volume, did you say?
First volume, my lord, behind tab 17. And if we pick it up from page 314 of the bundle...
So you have to give me the number again.
314, my lord, of the bundle. And you see there's a heading at the bottom, the nature of the claims. So I'm just contextualising passages which follow. So it's Authorities Bundle 1, tab 17, page 314, para 192, summarises the claim, and the claim being for inflation of the MSC, the merchant service charge, the merchant's claims of the added costs which they've incurred as a result of the MSC, which the acquiring banks have charged them, being larger than it would have been had there been no breach of competition law. The breach of competition law being the setting of the MIFs, which is an input into the MSC. So the two things are not the same. So already one is seeing that the way it's been pleaded here is correct by the merchants. What they've paid for is the MSC, and the question they're asking is, has that been inflated as a result of the infringement, which is different to the way it's been pleaded in this case. Then we have, moving on to 193 over the page, so yes, 193 at the top of the page. In each case, the merchant's primary claim of damages is for the pecuniary loss which has resulted directly from the breach of competition law by the operators of the scheme. That direct loss is prima facie measured by the extent of the overcharge in the MSC. And then you have at 198 at the bottom of that page, the question then arises as to whether the merchants are entitled to claim as the prima facie measure of their loss the overcharge in the MSC which results from the MIF. The merchants say that they are so entitled because they've had to pay out more than they would have done but for the anti-competitive practices and have suffered a pecuniary loss. Now what Visa said was that the claims are for pure economic loss and must be claims for the loss of profit. So that was the competing argument. So Visa was saying, you can't claim for the overcharge, you've got to take account of mitigation and downstream pass on. And the Supreme Court prefers the merchant's argument, and we can see that at 199. The merchants are correct in their submissions that they're entitled to plead as the prima facie measure of their loss, the pecuniary loss measured by the overcharge in the MSC. Don't have to plead a consequential loss of profit. You can see here that Fulton Shipping, just glancing down, is considered. Those cases, 203, the effect of the breach on the overall profitability of the claimant in each case was not the relevant measure of damages. And then if you go over the page to page 205, top of page 317, by paying the overcharge, the merchants have lost funds And then what's said is there are different things, different responses they could have had to that. One of them is to charge their own customers more, to pass it on, and that would subsequently have to be taken into account. And we say that our case is fully consistent with the scheme of Sainsbury's, because our case clearly does not involve assessing the overall profitability of the consumer. We accept that the question of pass on by the consumer downstream, particularly that would apply for business consumers, that's a question for another day. So that doesn't need to be deducted now from the loss that's sought. So it follows, we say, that it's the respondent's case that is inconsistent with Sainsbury's. The equivalent of the respondent's case would have been if the merchants in Sainsbury's had said, well, our measure of loss is the inflation in the interchange fee, never mind whether there was a difference in the MSC that we paid, in the merchant service charge that we paid. But they didn't do that. They did what we're saying should be done, which is sought to establish whether what they actually paid for MSC was inflated. Or the equivalent in Merrick's, which is, of course, an indirect consumer case, the equivalent in Merrick's to the class representative's case here would be if the class representative said consumers are claiming simply for the inflation of the interchange fee which is being sought to be passed through to them, never mind what they paid for the goods. It doesn't matter if the goods actually were not more expensive. They're claiming for the interchange fee because upstream it was always intended that would be recovered. That's simply not the pertinent question, and that's not what these other cases are doing. Going back to...
So just looking at 205.
Yes.
So the merchants, the first sentence, the court is referring to the merchants having, if they pay the overcharge, they have lost funds. But then they say there are 4 methods, which were those found at first instance by the CAT, by which those losses may be mitigated. And if any of those apply, that then serves to reduce and or eliminate the loss.
And that's downstream. That's
downstream. The merchants here are equivalent to the vehicle sellers.
The merchants in that case are equivalent to, no, they're the claimants. So
yes, but they are. It would be as if the merchants were the vehicle sellers suing the cartel. The people.
No, my lord, no. So
here, because they're the first line of attack, aren't they? The merchants. MasterCard overcharges them. They then maybe pass it on down the line to their retailers. On the facts of this case.
My lord, no. We look at it differently. So we say the equivalent is you have to ask yourself, so you start with who is the claimant and have they suffered loss?
Yeah.
So the claimant in that case was the merchants. And what they're saying is we've suffered loss because what we paid for, which is the merchant service fee charge, was higher than it would have been had it not been for the interchange fee agreement. Now, the equivalent in our case, you say who are the claimants? And then there's a question of, yes, but they then may have taken steps to mitigate or pass on that loss. Did that have to be...
I don't think I'm disagreeing with you. I don't think this is, in terms of a distribution structure, entirely comparable. The structure of 205 is that the merchants, in a sense, the starting point is if they've paid the overcharge, they've suffered a loss. But the court then goes on to recognise that loss then may be either eliminated or reduced in one of the 4 ways specified.
Yes. And so the equivalent in our case is...
You're option 3, aren't you?
My lord...
The customer reduces the price of the car by negotiating with the supplier of the car.
My lord, no, you have to distinguish between upstream and downstream pass on. And so in that case, the merchant was the claimant. And what was being said was they suffered an overcharge and they may have done one of these 4 things, which is passed on this overcharge.
Yeah, but the overcharge here is what the shipping company charged.
The overcharge... Here is what the overcharge here has to... So, yes, the cartel overcharge is what the shipping company charged. Yeah. That finds its way down the supply chain to...
I don't see why you're not option 3, because here you've got the charge which the shipper is making, and you say, well, the customer can eliminate that loss by negotiating a smaller price for the car, which would include the tyres and the windscreen wipers and all the rest of it.
My lord, because if you look at option 3, what option 3 is saying, the merchant can seek to reduce its costs Oh, I see. Can seek to reduce its cost by negotiation with its many suppliers. So what it's saying it's not saying that it can seek to reduce that cost. It's saying it can seek to reduce its cost generally. So the merchants are not seeking to reduce that's why we're not 3.
Right.
Because what it's looking at
I
is...
think.
I'm so sorry, my lord.
I think you're probably 4.
No, my lord, we're not any of them. So can I just explain why we're not any of them? So we're not 3 because you have to say doesn't matter where on the supply chain you are. The question is the claimant has got a claim for loss. That's the starting point. Now, what's being said under 3 is one form, perhaps, of dealing with a loss like that, is that where you're the merchant paying the merchant service charge to the banks, what you can do is say, well, I've got these, that's a bit higher, but I've got these other costs, for example, my cleaning company that comes into my shops, and you can reduce those.
Sorry, I'm just being simplistic here. If you are going to try and analogize this, isn't the merchant the equivalent of the car retailer? Because it's one stop off the end user.
My lord, it would be if this were a merchant claim. And so one has to you're looking at, in each case, you've got a claimant that's got a tortious claim for damage.
Now, I understand you're saying you look at the person who's making the claim.
Yes.
But if we're just forget for a minute that, if we're just looking at the structure of the chain in each case, there's an end user, and that's the end of the chain. And it's the car part buyer in the car case, and it's the customer in this particular scenario. The merchant is the person to whom the consumer, if you like, goes to buy something, just like the customer who goes to buy his car.
My lord, the problem is that the consumers in this case, in the class, are not necessarily the end of the chain, because there are business consumers that buy new cars. And so one of the points that will no doubt be made at trial if this goes forward is that those purchasers, the class members that have bought cars, if there was a loss, sought to pass it on further downstream. So it's dangerous, if I may put it this way, to take a snapshot of every supply chain is different, but the question of principle is you look at the claimant wherever they are in the supply chain, and you say, what do they need to, what's their claim? What's their tortious claim for a cartel overcharge? Their tortious claim is that they paid more for whatever they bought than they would have done if there hadn't been the competition infringement. And then the question is, yes, but they might have done things to mitigate, the claimant might have done things to mitigate that loss, that overcharge that they paid. And the question is, do those things have to be taken into account when pleading the claim, or are they matters which are dealt with later? And some of them are not dealt with at all because they're too disconnected. And the point is that downstream pass on of the merchants to consumers in their shops, those are the consumers that are in the Merrick's claim, that are bringing the Merrick's collective proceedings. That's something which will reduce the loss the merchants have suffered, but it doesn't go to reduce the loss claimed at the outset. That's the point the Supreme Court's making. And so you have to be quite careful when... The first point we make is that this doesn't assist my learned friend, because she says, well, our argument is that, contrary to the Supreme Court, what you're doing by saying you look at the transaction price is look at the overall profitability of the consumer. But we're not doing that at all. So that's the key point I make by way of defence, as it were, to the submission. Because what we're doing is simply doing what one does in an orthodox tort claim, which is to say, I bought something, a car, have I paid more for it and therefore suffered loss as a result of the cartel?
Well, what it would be wrong with the claimants here saying, well, we pay the delivery charge, you can see it on the invoice, and that was higher than it should have been. And then it is for you, as in Sainsbury's, to say, but you mitigated that prima facie loss by negotiating a discount, which is what they seem to be saying in paragraphs 207 to 211, that burden shifts to you to show, well, no, what you say is your loss wasn't really a loss at all.
My lord, no, because the equivalent in Sainsbury's, because that happened, so the equivalent in Sainsbury's is this, that you have the interchange fee agreement, which is the restriction of competition, and elevations in the interchange fee find their way are passed on through the merchant service charge. But the merchant service charge is not, it's not the same thing as the interchange fee. It includes other elements, including a markup by the banks. So, so the equivalent of what the class representative is doing, in this case, in interchange fee terms, would be for the merchants to have said, not that we're claiming for the inflation of the merchant service charge, but to say, well, it doesn't matter what the merchant service charge is that we've paid, we're claiming for the increase in the interchange fee. Doesn't matter, so as long as that's been increased and the banks have sought to recover it, doesn't matter if they've reduced the markup bit so that what we've paid is exactly the same in terms of the merchant service charge. So that's the equivalent point.
If it's a pleading point, 216 is also relevant. In terms of the structure, they pleaded, let's assume they pleaded an overcharge.
Yes.
You presumably pleaded your point about the fact that you've got to look at the counterfactual and look at the overall list price to see if there's any difference. Have you?
Well, no, we haven't got to pleadings. This is whether this claim can go
So you
forward.
will plead it?
Well, we're not if it's struck out, my lord. No,
Right.
that's the point of this appeal.
But looking at 216, the burden lies on the operator to establish that merchants have recovered the costs. So if it's a pleading point, they plead their overcharge. You will come back and say that's nonsense because you fundamentally missed the point. You've got to look at the counterfactual. There is no difference. There's no analysis of the list price. Then there is a really serious issue joined on the pleading.
My lord, no, because it's the same answer that I just gave to my Lord Justice Lewison, which is what that's looking at. So that's looking at once. So there are two stages, if I can put it this way, that are being recognised in this judgment. The first is, what's my claim for loss? And we see that from paragraph 198 at the bottom of 315. In fact, we see it from 314, 192. The merchant's claims are for the added costs which they've incurred as a result of the MSC being larger than it would have been if there'd been no breach of competition law. Now, the point that my lord's just put to me, oh, well, this can all be dealt with at trial, that...
Well, almost at the earliest stage, it's when the issue crystallises. I mean, I understand, but obviously one's got to be careful about using the facts of this case too precisely as a comparative with the present case. One of the questions we'll have to grapple with is what burden do we expect a claimant to put in the first instance before you put in a defence, before there's disclosure? And in a sense, we know what your defence is going to be. Will that not then govern disclosure? I mean, what is the sequence in which this court is going to require claimants to set out the full nature of their case on cost without a defence, without disclosure, without evidence?
My lord, think about it in strikeout terms, if I can put it in strikeout terms. So somebody files a claim which is bad in law. So we say, assume you're with me on it's bad in law, so it doesn't tackle...
It's bad in law, there's no issue about it, it's dead.
Well, my lord, we say it's bad in law.
Yeah.
So that's our first point. We say it doesn't measure loss as the tort requires. So that's the first response and key response really to the point that you've put to me. Now, if they had pleaded a claim that was good in law and we were just tackling the methodology and we were saying, well, they've got this methodology which is designed to compare prices of cars, which is the right thing, but we don't think they do it very well because they haven't looked at this, that's not very robust. Those are all points we accept that could be ironed out on disclosure and at trial because they're on the right track and it's too soon to expect them to we're not expecting a counsel of perfection at all, but we're on the wrong track. That's really the key point.
So it would have been all right for them to say that in the real world, consumers paid more for their cars than they would have done in the counterfactual, and you can measure the difference by reference to the delivery charge.
My lord, that may have been all right had they so had they said no, that by itself would not have been all right because we say that the methodology is not measuring for all the reasons I've given is not measuring. It's not tackling these points about how a list price is set, how are negotiations conducted, and it might be, for example, that 99% of negotiations are conducted in the way that we say, which is alighting on the round figure, and would have resulted in the same price in either way. So what they would have had to have done, so had they approached the court like that, had they pleaded it properly and said, right, we're looking at car prices, but that's going to be difficult for X, Y, and Z reason because it's difficult to get data. So what we're going to do methodology-wise is something different. We've got this proxy for car prices, which is delivery charge items. And we recognise that that doesn't establish by itself that loss may be suffered. We need supplementary evidence to show you that that's plausible. They could have done that had the evidence been available, but they didn't have any of that evidence at all. So I'm saying Mr. Pitchnin has now said to me, I've got rather carried away in saying they had no evidence at all. He said that there was a little bit of responsive evidence about how business purchasers negotiated for large fleets, but there was nothing that dealt with our case on list prices or negotiations generally. So, and the reference is, if we can go to the supplementary bundle, I don't need to go to it, don't worry. I've conveyed the point, and Mr. Pitchin is quite right to correct me. So that's Sainsbury. Can I take you to Fulton Shipping, which is the next case relied on by my learned friend? But that's in the same bundle, tab 14. So the court, I'm sure, is familiar with the facts. It was a claim of breach of a charter party by charterers of a cruise ship, and the breach resulted in the owners accepting the repudiatory breach and taking earlier possession of the ship than they otherwise would have done. And that was, in a sense, timely for them, because it meant that they sold the ship, they took possession of it and sold it in 2007 before the financial crisis.
Is it really not reported anywhere?
I was wondering that myself. I'm so sorry. It must be. We can find...
Even in Lloyd's?
It is in Lloyd's. I think I've seen it in
Lloyd's.
Lloyd's. It is in Lloyd's.
Anyway.
My lords, I can only apologise. We'll send you the reported version. Oh, tab 13. It's in tab 13. It's me that's looking at the wrong version.
Oh, even in the weeklies. Yeah.
I don't know why we've got it twice.
Yes, all right.
So sorry. So as I was saying, so the repudiatory breach of contract resulted in the owners getting the ship back in 2007 and being able to sell it in 2007, which was fortuitous because then came along the financial crash in 2008, and had there not been the breach of contract, they would have got it back in 2009 and they wouldn't have achieved as much on the sale. And the question was whether the damages should be reduced to reflect this separate transaction, which gave rise to a benefit.
I think they could have sold the vessel notwithstanding the charter.
Exactly. And so
At any point.
I don't think we really need to turn up the detail of the reasoning. We just say you don't get to that analysis of whether there's causation between the different transactions, because there simply is no different transaction.
You said there's only one transaction.
Exactly.
The consumer buys a car.
My lord, yes. And that's what the tribunal found. And so we don't, in a sense, need to look at the detail. Separately, the respondent relies, at paragraph 41 of their skeleton argument, on this court's judgment in Allianz. I'll just take you to that. So it's really to make good the same argument from their perspective. And again, our response is the same. But just to show you the judgment, that's in the second authorities bundle. Behind tab 21, and you'll see from paragraph 2 on page 551 of the bundle that this was a case where the claimant investment funds allege that they've suffered loss on foreign currency transactions as a consequence of anti-competitive conduct on the part of the defendant banks. And what the banks allege by way of defence, you can see at paragraph 3, they say that the funds have avoided or passed on the losses to the extent that investors in the funds have subsequently redeemed or withdrawn their investment at a NAV which was lower than it would have been but for the alleged infringements. And in a sense, we don't need, again, to go to the detail of the judgment. The court here found that those were separate transactions which didn't fall to be taken into account. and there was no causative link between them. But that's very different, and my learned friend relies on that. That's very different to the present case, where we say there's one and the same transaction. And just to give you a flavour of the court's reasoning, if you look, so if you go to paragraph 558, paragraphs 30 and 31 summarise some key authorities, including British Westinghouse and Swinson. And you see at paragraph 31, Swinson says that collateral benefits are those, I'm looking at in the middle of the inset, the citation. Broadly speaking, collateral benefits are those whose receipt arose independently of the circumstances giving rise to the loss. And then what's said here on the facts, if you go to page 560, in paragraph 37, is, well, these redemptions, which were redemptions according to the fund's rules, and in many cases took place many years later.
So which paragraph are you on?
37.
37, yeah.
On page 560. These redemptions are all independent, they're separate transactions. And you see that the court says at 37 that it's necessary to consider the nature of the transactions which gave rise to the benefit if it's to be regarded as arising independently of the fund's loss. And then you see that the redemptions are independent of the losses which were suffered in most cases many years previously on trades, and so they're just different transactions.
I suppose at base your point is there's no benefit here, there is simply a price paid. Whereas
That's right.
in Fulton there were two sums. There was the 21 million gain on the sale of the vessel as against the damages for the breach of charter party. There were two sums setting one against the other. Here you've just simply got a single price.
My lord, yes, that's our simple point.
The benefit is, in a sense, it doesn't exist.
Yes, exactly. It's
Just the price.
It's not the right way of analysing it. It's not a benefit, it's just the price, exactly.
Well, in all these cases, there's a pot of money which claimants can recover. It's 100%. That pot of money is shared between all those who can claim the 100% and divided aliquo as between them.
Yes.
But if there's been a negotiation and reduction and you've only paid 30, you can't claim 100.
My lord, and what the argument that's made against us here under Fulton shipping and benefit is extremely artificial, or we say it's wrong. But what they're saying is really that any benefit obtained by the class in the negotiation is conferred by a third party. So,
i.e. the shipping company. But then the class do not become victims of the tort unless and until they buy a car at an inflated
exactly,
price.
my lord, that's exactly the point. So I'm not going to. Those are our submissions on that. So I'm not going to labour that any further. So finally, the third argument in their skeleton, if we can just pick up their skeleton argument again. So core bundle tab 7, page 106. The third argument is the scope for adjustment of trial. And it's illuminating, we say, to look at the example they give at paragraph 44 of the type of adjustment that can take place. So at paragraph 44, they say, tribunals, on the facts of this case, the tribunal's assessment that the respondent's proposed methodology could be adjusted at trial had a clear basis in the evidence before it. In particular, the respondent's economic expert, Mr. Robinson, explained in his second report, even if all car rental companies were able to refuse to pay the delivery charge in its entirety, underlying delivery charge, this can be easily identified and would not have a material reduction on the estimated claim. By way of example, based on a 10% overcharge, car rental companies only account for 4.1 million. So this is illuminating because, again, it's focusing only on the delivery charge. And one can, in a sense, think about it like this. So they're saying, well, we accept, presumably they accept, that's why they're saying this adjustment can be made, that if somebody comes along, if a consumer comes along and says, right, you've itemised this £500 delivery charge, contrary to their evidence about how consumers normally behave, we're not going to buy the car unless you knock off this £500 delivery charge, they would accept that there would be no loss. That's why they're talking about exclusion from the class. But if the very same consumer used different words in the negotiation, and they said, right, this car is £22,500, we want to buy the car for £22,000, on their case, there would be loss, because you don't look at that, because it's not negotiating the delivery charge item. And that really, in my respectful submission, illustrates why they've gone badly wrong in principle here, because it can't be the case that whether or not there is loss depends on the words used in a negotiation. And the reason why they're driven to that is because of this extremely artificial approach, which is you don't look at the transaction, you separate out, you silo out the delivery charge.
If you do look at, let's assume you look at the transaction as a whole, and you discover that there's been a 5% reduction in the final price, would the CAT then be able to just pro-rata that across all elements, all components of the cost, and say everything's been reduced by 5%, including the overcharge?
Why not? No, because they're disavowing any case based on the final price.
I understand there's a pleading point behind this, but just standing back as a matter of logic, would not that be a broad axe way of approaching damages?
Well,
just pro-rata?
No, because it would depend. So you're saying, so can you put it to me again?
Yeah.
Sorry,
Let's assume the overcharge is, sake of argument, 0.5% of the total sale price of the vehicle. And then at the end of the day, you or I, we buy our vehicle and we negotiate 5% reduction off the total price. Can't you just use those two figures to come to a conclusion as to how much the overcharge has been whittled away by negotiation, just by pro-ratering the rate of negotiation?
So I think one of the difficulties with that is that implicit in what you've just put to me is an assumption on which there was no evidence.
I understand that. I'm just, as a matter of principle, we're long way from trial. By the time it comes to the trial, assuming, for the sake of argument, it goes ahead, I mean, surely this is relatively straightforward for the CAT to say to the parties, right, conduct this calculation for me. Here are the percentages, here's the findings we're making as the facts. Just as a matter of abstract analysis, I don't see any particular difficulty. Forget pleadings, forget evidence. Just as a matter of approach, is there anything terribly difficult about it?
Well, my lord, so seen in the abstract, the mathematical calculation is not difficult, but the problem is, does it equate or approximate to loss? We're not saying.
I think your point really is that you've got to establish that the price in the real world was higher than in the counterfactual.
Yes.
Unless you can establish that one way or another, you don't get anywhere
Exactly.
on loss. If you can establish that the price in the real world was higher than the counterfactual, then of course you may be able to apportion the difference as between various components.
My lord, that's exactly so. And it may be that at that stage, had they put forward a methodology and a case that says, this is how we're going to do it. So we're not going to do it we recognise that we need to establish that the price of the car is higher than in the counterfactual. But we're going to do it by looking at the delivery charge. And the reason why that's reasonable is because actually 90% of people negotiate in this way by seeking the £500 reduction, and list prices are never affected by, the profit margin's never affected by input costs. Then that would be an extremely different position. But then the CAT would have had to have examined that evidence. We may or may not have had objections to it. It may or may not have led to a claim on behalf of all of the class. What if the evidence had established that in 50% of cases, list prices would vary, so the list, or rather would not vary, because the profit margin would fluctuate depending on competition in the market? Or what if it established that at least 50% of consumers don't negotiate in the way preferred by the class representative? Then the CAT would have been faced with a different claim, a much smaller claim. And so when it was looking at other questions that arise on certification, like cost-benefit and like funding, it would have been looking at a smaller claim. This claim is already not huge in the scheme of things. So, my lords, I've gone slightly over time. I'm just going to draw my submissions together quickly, if I may. And we say, I'm going to take you briefly to this court's judgment in Gutmann, but very briefly because Mr. Singler is going to deal with it in more detail. So that's in the third volume of authorities. Behind tab 26. And I just want to take you directly to paragraph 56 on page 873. And to this point that the court made there. So it says, issues, not answers. At the certification stage, the methodology must identify the issues, not the answers. The CAT is concerned to identify the issues and gauge whether the methodology proposed for determining those issues is workable at trial when the issues are tested. And short point, for all the reasons I've given, they simply haven't identified the correct issues. We're not making a point about the robustness of an analysis which does hit the right target. It just hits the wrong target. So we're not in the type of case envisaged at the end of paragraph 58, which is the broad axe Merrick's type case, where what's claimed is accurate in law, the methodology is broadly right, but it's all very difficult, and the data is not available at the certification stage. That is not the case we're dealing with. And then at paragraph 61, the court makes the point there that, and looking at the end of paragraph 61 on page 875, the CAT plays an important gatekeeper role in certifying claims, will always vigilantly perform that function, seek to strike a balance between the right of the class seat vindication, the right of defendants not to be subject to a top-down claim unless it's a proper one to proceed. And we respectfully endorse what the court says there, and we say that if this is not a case in which the CAT should have excised its gatekeeper role, then what is? Because the flaw that we've identified is fundamental. It's not a problem that can be remedied by using a broad axe. Their claim is not reasonably arguable because it alleges the wrong loss. The methodology fails to identify the issues. It's not a question of failing to give the answers. It's targeting the wrong thing. And we say for that reason, the gatekeeper role of the CAT is engaged, and for the reasons we've given also, the case is not reasonably arguable and should be struck out. My lords, unless I can assist any further, those are our submissions on this appeal.
Thank you very much, Mr. Mitchell. Yes, Mr. Singler.
My Lords, on behalf of KK, the fourth defendant, we agree entirely with the argument advanced by the other appellants, and we gratefully adopt the submissions of Mr. Dimitriou. But we advance a further or alternative reason why we say the collective proceedings should not have been certified. Now, we say the tribunal erred in holding that the methodology satisfies the Microsoft or the process test. And specifically, the point of law raised by our appeal is as follows. Is the process test satisfied where the class representative has put forward a proposed methodology for quantifying the loss allegedly suffered by the class, which will only work in the event that the industry evidence is entirely accepted at trial? Or put the other way around, is the process test satisfied if the methodology will not work in the event that some or all of the defendant's evidence is accepted at trial? And we say the answer to both of those questions is no. And to develop this a little, before I come back to the material in more detail, as you've heard and as you will have seen, there are two main parts to the methodology for quantifying the loss. Part one concerns measuring the extent to which the infringement found by the European Commission resulted in an overcharge in shipping costs. And if there was an overcharge at that stage, that would have been incurred by the OEMs at the first level of the supply chain. Now, so far as that is concerned, Mr. Robinson of BDO explains he intends to use a conventional regression model. In other words, comparing shipping costs during the cartel period and after the cartel period. Now, we don't take issue with part one of the methodology at this stage, but it's part two, which is the focus of our attack, and which we say fails the process test. Now, part two concerns the extent to which any overcharge at that first stage of the supply chain may or may not have been passed down through multiple levels. So first, from the OEMs to the national sales companies. Secondly, from the national sales companies to retailers. And then thirdly, from the retailers to the end customers. And of course, unless that overcharge has made its way all of the way down the supply chain, there is no claim. Now, what the proposed class representative has done in relation to Part 2 is, first of all, they've served witness evidence, as your lordships know, the industry evidence of Messrs. Goss and Whitehorn. And in a nutshell, they say that they believe it was standard industry practice throughout the claim period for shipping costs always to be passed on in their entirety, all the way down to end customers. And then, building on that evidence, what the class representative has done is serve a report from Mr. Robinson, who says, well, on the assumption that all of that industry evidence is correct, this is how I would go about quantifying the alleged loss. Now, the crucial point which I want to emphasize at the outset, and really the core of our submission, is there is no attempt by Mr. Robinson to measure empirically the extent to which any overcharge may or may not have been passed on. So in contrast to what he's doing at Part 1 with the regression analysis, there is actually no methodology at all for ascertaining the extent to which there may or may not have been passed on. And all we have is Mr. Robinson saying, well, on the assumption the industry evidence is correct, here is the quantum. And I will show you later, my lords, that Mr. Robinson makes perfectly clear in his expert reports that A, his methodology proceeds entirely on the basis that the industry evidence is correct, and B, he has not given any consideration to what alternative methodology he might deploy in the event that some or all of that industry evidence were to be rejected at trial.
Why does that matter at this stage?
My lord, as I'll come on to explain, it matters at this stage because the process test we submit requires the court to be satisfied that the methodology works even in the event that the defendants succeed on certain issues at trial. Mr. Mitriou has taken you to paragraph 56 of Gutmann, and that I'll come back to, but we submit it may be sufficient to overcome a summary judgment application to say, well, this is how we intend to prove our claim. This is what our industry evidence says, and if that is accepted at trial, we will quantify the loss in the following way. We accept that on that basis, a summary judgment application would not succeed. But what we submit is when one is applying the process test and taking into account the important gatekeeper role, one has to have in mind what may or may not happen at trial. And we submit that unless the methodology is workable in the event that the industry evidence is rejected, then we say that the case should not have been certified. In fact, we say that the tribunal has committed an error of law insofar as it has held, well, they've served industry evidence, that's not been undermined at this stage, and therefore we'll have to see what happens at trial. We say no, the methodology needs to be workable in the event that the defendants succeed on some issues at trial.
So you've got to predict at the outset what your defence might be and what their response to your defence might be.
Exactly, and indeed I'll show
But
you.
they must do that at the certification stage.
Well, my lord, what we
even
did.
though you haven't yet pleaded a defence or put in.
Well, with respect, no, my lord. As I'll come on to explain, what we did is we served some brief evidence explaining that we did not accept the industry evidence, and we were not asking the tribunal to make any findings of fact at the certification stage. Plainly, they can't do that. But what we were saying is, at trial, our case will be as follows on the facts. And the gauntlet that we threw down was to say, well, if that is what happens at trial, and we put you on notice, we haven't served a defence because we haven't got to the pleading stage, but we have told you fair and square that we do not accept the industry evidence.
But if your case is that the consumers paid no more for the car in the real world than they would have done in the counterfactual, that's the end of the case anyway. Doesn't matter what methodology.
Absolutely, my lord. That's why our position is a supplementary point. So we also rely on Mr. Mitriou's argument. We say the case should have been either struck out or held not to satisfy the process test for that reason. But we say an additional problem with the methodology here is that it's entirely premised on the basis of what the industry evidence says. So, my lord, yes, we absolutely agree that we don't need this point if your lordships accept what Mr. Mitriou has been submitting. But we do submit that this, in fact, when one looks at what the proposed class representative has done in terms of methodology, it's highly unusual, and it's unlike any other case that has been certified to date, because, as I say, there's no attempt actually to measure whether or not the shipping overcharge was passed on. It's simply on the say-so of the industry evidence. Now, my lords, what we submitted below was that, as a matter of principle, the process test works in the way that I've just outlined, i.e. the tribunal needs to have regard to what the defendant's position on the facts is going to be at trial. And since the CAT's judgment, we obviously have the Gutmann judgment, and we say paragraph 56 is exactly on point. And importantly, as I'll come on to explain, this is not a scenario in which the broad acts can help the proposed class representative. This is not merely a case of making adjustments at trial, because in fact, it's a more fundamental point than that. We say an entirely new methodology would be required if one was truly working out the extent to which pass-on may or may not have occurred. One actually needs an entirely new methodology. It's not simply a case, as it was in Gutmann, of the court saying, well, we might be able to carve some customers out of the class at trial. We say this is a completely different case. My lords, with that introduction, what I propose to do is first address you in a bit more detail on the methodology to make good some of the points I've already summarised. Secondly, I do want to take you quite closely through my Lord Justice Green's observations on the process test in Gutmann. And thirdly, I will go to the tribunal's judgment, and for your lordship's note, the relevant paragraphs where they deal with this argument, paragraphs 105 to 113. And to be clear at the outset, we do say they've committed an error of law in this regard. And then finally, I will look at Miss Ford's skeleton, where she makes essentially 2 points in defence of the tribunal's judgment, and we submit neither has any merit. Could I perhaps, in the 6 minutes, just show you the claim form, which is what I wanted to do.
Claim form?
Yes, and then perhaps we can pause there. So I just want to show you the claim form in relation to the methodology to see exactly how the case is put. That's supplemental bundle 1, behind tab 1. If I could start by showing you paragraph 7. As your lordships would have picked up, the claim form is somewhat different to an ordinary claim form or particulars of claim. But I just want to show you how the methodology is incorporated within this document. So paragraph 7, more particularly the proposed collective proceedings will combine the claims, but it's the second sentence. As the proposed representatives, industry experts explain in detail in their joint report, the price which manufacturers pay for their vehicles will always be recouped via the downstream supply chain and are ultimately borne. And then one has paragraph 8, which Mr. Dimitriou took you to earlier, but if I could pick it up at subparagraph 5 on page 5, again, just to show you how Messrs. Goss and Whitehorn's evidence is being relied upon. So in other words, the shipping costs which an OEM incurs are a direct input into the ultimate delivery charge. The proposed representatives, industry experts, are clear that every person who purchases, and you'll see, will pay a delivery charge that has been calibrated. So it's every person is said to pay this delivery charge based on the industry evidence. And if one moves forward to page 12 of the bundle, this is picking up paragraph 40, subparagraph 3, subparagraph A. As Mr. Goss and Whitehorn explained, shipping costs are a direct input. As they further explain, such delivery charges are invariably paid for. And then at B, one can see the second sentence, the scenarios that appear in the BDO report take into account the evidence given by Mr. Goss and Whitehorn to the effect that OEMs, NSCs always seek to maintain a healthy margin on delivery charges, and B, with that in mind, OEM NSCs would certainly have passed on any price increase in order to maintain their margin. And there are more references, if I could just give you 2 more. Page 16 of the bundle, paragraph 43 of the claim form explaining the class definition, and the final, the penultimate sentence on that page. It's the end customers who are within the class. That is because, as Mr. Goss and Whitehorn explained, delivery charges are borne entirely by the first person to purchase or finance a vehicle. And then the final reference I wanted to give you is page 37. This is picking up paragraph 61, subparagraph 7. this is consistent with the clear and unequivocal views of Mr. Goss and Mr. Whitehorn, that delivery charges are highly likely to have been universally passed on. So, my lords, what is clear is that the pleaded case is put exclusively on the basis of the industry evidence, and I do emphasise the references to always, invariably, certainly, entirely, universally. And we do stress that there is no pleaded case which involves any claim on the footing that there might be some lesser degree of pass-on. It's all premised on the basis that the industry evidence is correct. And I'll show you after the adjournment that that's also the way in which Mr. Robinson has proceeded when quantifying the aggregate damages. My lords, I was going to move on to explain the industry evidence in a bit more detail. I wonder if that's a convenient moment. It may take me a few minutes.
5 minutes now?
5 minutes, I should be able to explain.
Right, you do it.
I'm grateful. So Mr. Robinson, as I say, works on the basis of the industry evidence, which is summarised, again, for your lordship's note, paragraphs 80 to 83 of the judgment. But in my respectful submission, that summary is somewhat compressed, and I do just want to take a few minutes to explain and emphasise certain aspects of the industry evidence. Now, all of this is common ground, I should say, but what they're saying, Messrs. Goss and Whitehorn, if we take the three levels of the supply chain in turn, is at the first level, they are saying, and I should say this is also summarised at paragraph 19 of our skeleton argument, if that persists. But at the first level, so it's the OEMs who initially incur any shipping overcharge, they are saying that each and every OEM always passed on 100% of any alleged overcharge throughout the relevant period. So that is what they're saying. This is a universal rule that this was happening in relation to every OEM, passing on 100% of the alleged overcharge. So that's from the OEM to the NSCs, which is the first level of the supply chain. And I pause there to note that that's irrespective, of course, whether or not we're talking about the same corporate group. They say it's always the same, whether or not the OEMs and the NSCs are the same corporate group or not. That universal rule applies. So then we look at the second level of the supply chain. This is the NSCs. Now here, Messrs. Goss and Whitehorn say that each and every national sales company had exactly the same pricing strategy for setting the level of delivery charge to retailers. And they say, again, this was always implemented throughout all of the relevant period. And that pricing strategy is said to have been as follows, that the delivery charge was always set so as to ensure a specific minimum profit margin, which the NSCs always wanted to maintain. So that if shipping costs increased, then each and every NSC would always have increased the level of its delivery charge. And again, that would have been the case, we're told, throughout the entirety of the period. And that's the justification for looking at movements in the delivery charge and attributing any increases to the shipping overcharge.
And when you say they wanted to achieve a profit margin, you mean on the delivery charge?
Generally, my lord.
Across the board, all costs or just on the delivery charge?
All costs. The theory is...
as they pass down the distribution change? Exactly.
So what is being said, the references... I can give you the references. But,
right. No, I'm just clarifying what you were saying.
Yes,
understand.
What they are saying is that the way in which the NSCs run their business is they always have to maintain a minimum level of margin. And therefore, if, as an example, one input cost, shipping overcharges or shipping costs increase, because they have to religiously protect their margin, they will necessarily pass that overcharge on. So it's its margin across the board needs to be maintained. And therefore, shipping costs are just one example. But that's the basis on which they say, and the class representative says, you can just assume that any increases in the delivery charge are attributable to the shipping overcharge. Conversely, however, and again this is a universal rule, the delivery charge was never reduced if shipping and other costs decreased. So that's what's being said. And now, making some brief observations about this stage of the evidence. First of all, this is not a cost-plus pricing model, so your lordships may see in the papers some references to that. In fact, it's not. It's an asymmetric pricing model. Prices go up if costs go up, but prices do not go down if costs go down. And just to emphasise again, this is being said in relation to every single national sales company throughout the period. So regardless, for example, of financial market conditions, the relevant period includes the financial crisis in 2008, that on this evidence is entirely irrelevant. The NSCs would always have behaved in this way. And this is also said to have been the practice of NSCs, whether or not they had itemised delivery charges. And your lordships, I think, have that point, that no distinction is drawn between those who split out the delivery charge and those who have a single price. And if I just finish on the third level of the supply chain, here it's being said that each and every retailer, throughout the entirety of the period, always passed on 100% of the delivery charge. And again, that's irrespective of market conditions, that's irrespective of whether or not there was an itemised delivery charge, that's irrespective of the nature of the end customer. Is it a big corporate customer buying a fleet of vehicles, or is it an individual purchaser? It doesn't matter on the evidence of Messrs. Goss and Whitehorn. And it's also the case that it's being said that the overcharge would have been passed on, or the delivery charge would always have been passed on, regardless of the fact that, I think Mr. Dimitriou touched on this earlier, that indeed some brands are not even within the scope of the claim. So there are some vehicle brands where shipping overcharges or shipping charges were not incurred because they were manufactured within the EU. We say, well, an obvious point is retailers would need to look at what those brands are doing and set their prices, at least in part by reference to competitive benchmarking. But that doesn't matter on the theory that's being expounded by Messrs. Goss and Whitehorn. So that, I just wanted to emphasise that that is the nature of the evidence. And perhaps after the adjournment, I can show you what Mr. Robinson does building upon that industry evidence.
Did you have a question to ask now? All right. Thank you. 2 o'clock.